Zunate, is everything okay now?
Yes, ACJ, we may proceed, thank you.
Okay, the clerk can call the matter.
Good morning. I am the Registrar Clerk for this hearing. Acting Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of United Democratic Movement and another, and Lebashe Investment Group Pty Limited and others for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Thank you. Good morning, Acting Chief Justice, Justices. I appear for the appellants with my learned friend, Mr. Ngugai Toby and Ms. Dewey.
Thank you very much. Good morning, Mr. Mpofu. Thank you.
Good morning, Acting Chief Justice, Justices of the Constitutional Court. I appear for the respondents in this matter, together with my learned friends, Mr. Slon and Mr. Makhalemele.
Thank you very much, Mr. Berger. Mr. Mpofu.
Thank you very much, Acting Chief Justice. Well, Acting Chief Justice, unfortunately, I have to start with bad news.
I suspected that you give me bad news first.
The discussions did not bear any fruit, partly because of the lateness of the hour and the difficulty in getting instructions.
Yes. Okay.
Thank you.
That's all right.
Thank you, SCJ.
Thank you.
Acting Chief Justice, with your leave, please can you ask Mr. Mpofu to turn his video on?
Oh, okay.
My video is on.
Yes, I can see him.
Yeah,
it's on. It's on.
Okay, thank you. My apology.
Okay, all right.
Thank you, Justice Tana.
Thank you, Mr. Mpofu.
Yes, thank you. As far as the appeal itself, ACJ and Justices, we're going to split the argument. Mr. Ngugai Toby will deal with the appealability point, and I will deal with the merits of the appeal. And therefore, Mr. Ngugai Toby will go first with the leave of the court.
Mr. Ngugai Toby.
I think he's muted.
Oh, is that so? Mr. Ngugai Toby, you surely want us to hear you, isn't it?
I was muted, Acting Chief Justice, perhaps for good reasons.
Yes.
What I propose doing is to address three topics under the heading of appealability. The first is to persuade the court that the SCA did not appreciate the broad interest of justice standard for appealability of interim orders in relation to the matter that was before it. The second is that in any event, the SCA was wrong in its assessment of the impact of the order when it found that there would be no irreparable harm. It found that the effect of the order was merely to stop Mr. Holomisa and the UDM from repeating material which was already in the public domain, and it considered that not to be irreparable. And the third point is that in any event, the SCA's approach to appealability was wrong because it limited expressly the rights of the UDM to speak only in Parliament. But what I suggest is that it should have recognized that the impact of the interdict was wider. It affected Section 16, it affected Section 58 of the Constitution. And on authority of this court, that speech also applies to conduct outside of Parliament. And the statements themselves that were made by Mr. Holomisa were protected speech based on substantially accurate facts, and he was entitled to comment on those, even if his commentary was outlandish. If I could start then with the first question about the appealability test. The court will see the judgment of the SCA at record volume 5, and it starts at page 417. The majority judgment ends at 435. And you will see that at paragraph 12 of the judgment, which is at page 427, the SCA expressly says that the reason why the order of Justice Tlhapi couldn't be appealed is because it cannot be interpreted as having final effect in any accepted sense of the concept. And it repeats that at various parts of the judgment. And ultimately, it comes back to it at page 434 in its conclusion at paragraph 26. So it's quite clear that the SCA was wedded to the notion that a judgment, an interim order, is appealable only if it has final effect. However, the problem with that finding is that it overlooks the judgments of this court in relation to when interim orders may be appealable. We've cataloged those in our heads of argument. They start from outer informal traders, City of Tshwane. All of those judgments make it clear that even if an order does not qualify as having a final effect in the traditional sense of S versus Zweli, they can be appealed or are appealable if their impact is substantial, it is ongoing, and it produces irreparable harm. So the first point of criticism of the judgment of the SCA is that it applied an outdated test in S versus Zweli, and it failed to apply the prevailing test that emerges from the judgments of this court. In any event, the SCA itself has previously endorsed the test that we say should have been applied. I found last night the judgment of Director General, Department of Home Affairs and another versus Islam and others. It is reported in 2018 ZASCA 48. At paragraph 10 of that judgment, Justice Meyer wrote on behalf of a unanimous Supreme Court of Appeal and said the following: at the outset, I agree with the appellants that the interim interdict is appealable. Traditionally, under common law, an interim order was not appealable, except where it was shown that it was final in effect, as it could not be altered by the court which granted it, definitive of the rights of the parties, in that it granted definitive and distinct relief, and C, was dispositive of at least a substantial portion of the relief claimed in the main proceedings. And for that authority, she cited S versus Zweli. But then she continues to say, the test has since evolved. So, whilst the traditional requirements are still important considerations, the court may, in appropriate circumstances, dispense with one or more of those requirements, if to do so would be in the interest of justice, having regard to the court's duty to promote the spirit, purpose, and object of the Constitution, e.g., where the interim order has an immediate and substantial effect, including whether the harm that flows from it is serious, immediate, ongoing, and irreparable. So we say that not only did the SCA not apply the test that has been authoritatively laid down in this court's judgments, it also didn't apply the test in its own judgments, which expressly recognizes that where the interests of justice require, an interim interdict would be appealable. So that's the first point we make on why the SCA got it wrong on appealability. The second point, in any event, we say that if one looks at the impact of the order, it is clear that the impact of the order produces irreparable consequences, or what is called irreparable harm. This we can see by looking at the order itself. If one looks at the order of the High Court, we will find that order at volume 4, page 366. Just 2 points need to be made about that order. If one looks at page 367, paragraph 1.1, what Mr. Holomisa was prohibited from doing was he was stopped from making or repeating any allegations and were including but not limited to internet posts, articles, letters, media interviews, Twitter, and other social media posts and the like. So it's quite a wide interdict. Then if you look at paragraph 1.2, it says within 3 days of the granting of this order, he is ordered to remove and delete the letter. And insofar as it lies within their power, any posts regarding the letter or any of its contents or responses thereto. So it's a combination of those two orders. Firstly, he is told you cannot make or repeat the statements contained in that letter. And then secondly, those statements that have already been made and have been published, they are to be removed. Both of those show that actually the order is final in effect and that its impact is irreparable. Now, we see the problem with the approach of the SCA is that it didn't seem to appreciate that the nature of the order also directs him to remove posts that have already been published. In fact, the judgment proceeds on the assumption that the only impact on Mr. Holomisa is that he may not repeat the statements. It simply completely overlooks the fact that he has been told to go searching in the internet and remove all of those statements. So we say on the second part of it is that if one looks at the order, properly speaking, firstly, its width in paragraph 1.1 and its impact in paragraph 1.2, it shows that it's actually final in effect and its consequences are serious, ongoing, and I think definitive of Mr. Olomisa's rights during the period of the time before the judgment of the High Court is to be delivered. And presumably after the judgment of the High Court is delivered, in the action, there will be appeals. And during that entire period of the appeals, he will be constrained from making those statements that were contained in the letter. So we say that the second part we make is that the SCA in any event was wrong in its impact of the assessment of the order. It should have recognized its irreparable nature, and it was wrong in narrowing the scope to repetition. In fact, it's not mere repetition. He is told to go scouring the internet and to remove any material that has any reference to the statements that were contained in that letter. And then the third point that we make is that in any event, the SCA is wrong in limiting, and one will see the judgment of the SCA at page 432, paragraph 23, where they say the appellants are in addition not denied the opportunity of repeating the allegations in Parliament because section 58(1)(a) of the Constitution secures a right to do so with impunity. So the point we make there is that the SCA is wrong in limiting the rights of the UDM to only speak in Parliament. What it should have recognized is that the UDM also has rights under section 16, and that as per the authority of this court in Dikogo, the section 58 rights may in appropriate circumstances also be extended to speech outside of Parliament, provided that that speech is made genuinely in good faith and in pursuit of the role of an opposition politician. So we say that the SCA did not give any meaningful content to section 16 of the Constitution, and that a proper approach should have been that because the interdict will drastically impact and effectively muzzle Mr. Olomisa, it should have factored into the question of appealability. The SCA should have taken the view that bearing in mind the rights that are at stake, particularly the section 16 rights, the rights of Mr. Olomisa, to speak publicly about matters of public concern, the SCA should have thought seriously about granting leave to appeal. That, of course, there is a related right, which is under section 19. One must recall that Mr. Olomisa was not just speaking as any ordinary member of the public. He was speaking in pursuit of his role as an opposition politician, and he is entitled to do so under section 19 of the Constitution. And he has privilege under section 58. And on Dikogo, that privilege can sometimes extend to speech that is made outside of Parliament. In fact, what one gets from this judgment of the SCA is that the SCA seems to think that this is about speaking. It says you may repeat the statements you have made, but the order is actually an order to remove something that is on the internet. It is not the old public square where one goes to speak and there is a defamation interdict. What is happening here is that all of this is happening on the internet. And Mr. Olomisa has been told to remove everything that is on the internet that is related to these allegations. So the third point.
Mr. Ngogachobe, I'm sorry, your 10 minutes of address without interruption is up, but you may continue.
Thank you, Acting Chief Justice. So the third point we make, firstly, is the fact that the SCA did not appreciate the scope of Section 58, particularly as set out in the case of Digogo following Canadian jurisprudence, that the privilege that extends to members of parliament, Digogo was not about members of parliament, it was councillors, but the same logic applies to members of parliament, that privilege should not necessarily be confined to parliament. Even speech happening outside of parliament may be protected. But in this case, what we say, what is unique, is that the SCA does not seem to have appreciated the nature of the speech, that it is all speech happening on the internet. And the impact of that is not just to limit what you can say in parliament, but what the public can see from the web page of the UDM. And then the sub-point.
Mr. Ngogachobe, I would like you at some stage to address the question of whether, as a matter of law, the SCA had power to refuse to hear the appeal other than on the basis that it was moot, if it was moot. In other words, isn't the scheme of our legislation that a litigant gets the opportunity or the right to have their appeal heard by the Supreme Court of Appeal under different routes? The one route is that the High Court grants the litigant the right to appeal, and I'm calling it the right to appeal because I understand an order granting leave to appeal to be granting the litigant the right to appeal. That is the one route, and that the other route is where the High Court has refused leave, but the Supreme Court of Appeal has granted leave on petition. So before you finish your address, I would like you to deal with that for me. You don't have to deal with it now, but at some stage I would like you to deal with that.
Acting Chief Justice, let me deal with it now because I am going to address my third and final point and give over to Mr. Mpofu. What we have suggested in our submissions is that the SCA, having been confronted with the fact that Justice Tlhapi had granted leave, its job or its function statutorily, that is what we say in paragraph 61 of our heads of argument, was to hear and decide the appeal. It was not to revisit whether or not leave to appeal ought to have been granted. But there are judgments of the Supreme Court of Appeal, like Sipla, where the court says the mere fact that the High Court has granted leave to appeal is not dispositive of whether the issue before the court is an appealable issue. So they seem that as part of the sort of common law, if I can put it that way, to have reserved themselves the inherent power to revisit questions of appealability. Now, there is no need in this case to disrupt that line of authority that the SCA would, in certain instances, revisit and not regard itself as being bound by the decision of the High Court in relation to whether an issue is appealable. In other words, even where the High Court has said, we think that leave to appeal is granted, the SCA tends to reserve for itself the right to revisit that issue. But there is a better way of resolving the issue, which is that the SCA had no power, which is what Justice Mahoka said, to interfere with the discretion exercised by the SCA, by the High Court in this case, on the issue of appealability, except in narrow and defined circumstances. And if one reads the judgment of Judge Sutherland, he in fact never addresses himself to the issue of what the High Court get wrong. Never does so at all. He just proceeds on the basis that he's hearing this afresh and never says, this is where the High Court misapplied its discretion, which is what the SCA would have been required to do. So I would submit on this question, Justice, Acting Chief Justice, that there is case law that says that the SCA is not bound by lower court decision on appealability, and that this is not the case to disrupt that case law. There is a better approach to it, which is that the SCA simply never addressed itself to why it was rehearing the appealability issue, which had been anxiously but correctly decided by the High Court. And its judgment is quite clear that they just never applied themselves to it. What they thought they were doing, what they seem to have thought they were doing, they were hearing this leave to appeal essentially ex nunc for the first time, as if there was no determination on the issue. And fortunately, in this case, there was full argument before Justice Tlhapi on appealability. She applied herself, she decided that she would grant leave to appeal, and she expressly decided that the issue was appealable and granted leave to appeal on that basis. So that is what we would say, that there is no need to constrain the ability of the SCA. There will be future cases where it's necessary for the SCA to block a litigant, but this is just not one of those cases.
Mr. Ngugai-Toby?
But before you proceed, Mr. Ngugai-Toby, is there anything in the statute, the Superior Courts Act, that reserves this power to the SCA? Because that the leave to appeal is dealt with expressly by the statute.
Section 16, yes. Section
and the statute, and the statute, as I understand the position, makes provision for a situation where the SCA might refuse to hear an appeal, even though the High Court has granted leave to appeal.
Yeah.
And that is if the case is moot.
Yes.
If it is moot, the statute allows the SCA not to hear the appeal. But
yes,
maybe there is another exception which doesn't come to mind immediately that the Act specifies. But that is one example which the statute, so in other words, as I see it, subject to argument on both sides, hearing argument, it seems that the statute confers on the High Court the power to grant leave to a litigant. And granting leave to a litigant is giving that litigant the right to pursue an appeal. But the statute confers on the Supreme Court of Appeal the power not to hear an appeal in circumstances where even a right has been granted. And that is one example if the matter is moot. Maybe there might be other exceptions that I haven't picked up. Are there others in the statute that I haven't picked up?
No, Acting Chief Justice, there are none. This is all governed in Section 16 and 17. And it's quite clear that under Section 16 of the Superior Courts Act, the routes that you've outlined are the applicable routes. So one gets leave from the High Court and then goes to the SCA. Yes. Secondly, one gets leave directly from the SCA. And on both of those instances, the function of the SCA, and it's expressly stated in the statute, is to hear and decide the appeal. Yes. What is unclear is whether hearing and deciding the appeal incorporates the determination of whether the issue is appealable, because there is an express provision on Section 16.2, where it says, Section 16.2A1, when at the hearing of an appeal, the issues are of such a nature that the decision sought will have no practical effect or result, the appeal may be dismissed on this ground alone. So it doesn't appear that the intention of the statute is to confine the basis for the dismissal. It simply says may be dismissed on this ground alone. Remember that this appeal was not even dismissed, it was struck. It's classical revision of the decision of the High Court. They just re-entered the entire debate we had before Justice Tlhapi, and they decided to strike it. And so they neither decided the appeal, nor dismissed it for lack of practical effect, nor sent the appeal to a full bench as required by Section 16(6)(b). I would understand, Acting Chief Justice, if the SCA had engaged with the discretion and found the discretion to have been wrongly applied. Now, I would understand that. They didn't even engage with the discretion of Justice Tlhapi. They just did what they thought was right in the circumstances. And that would say that it is not an approach that should be endorsed. I'm reluctant to go with the view that in all circumstances, once leave is granted, there is no circumstance. It's unclear that would be correct as a matter of law. And I do, yes, I have my doubts if that would be correct.
You want to reserve that for another case?
For another case where the issue is going to be expressly to be decided. I think in this case, there is a clear-cut basis to overturn the SCA judgment, which is they interfere. Justice Makgoka said this in the dissenting judgment. He said, you've interfered with the discretion. You have no reason why you have done so. And the majority did not even revise its judgment in the light of the dissent to explain precisely what did Justice Tlhapi get wrong.
Thank you.
He never dealt with the case at all. He just struck it from the roll.
Okay, proceed. Thank you, Mr. Ngwaitobi.
Mr. Ngwaitobi. Thank you. Yes, my question might fall away in light of the half-hearted concession or this concession that you made towards the end of your response to the acting Chief Justice. The SCA has the power to regulate its own process.
Yeah.
Wouldn't that power include the power to strike a matter off the roll if it was of the view that the order was not appealable?
Yes, I mean, Justice Saron, I don't want to make the argument that the black and white argument that there are no circumstances where the SCA would, in the exercise of its inherent power, strike a matter that is not appealable. I think that reservation is probably a wise reservation. It's an old common law reservation. So that I would say the court should probably preserve. But this particular case is, in that sense, easier to decide because there has been a direct interference with the discretion of the High Court for insubstantial, in fact, for no reasons, let alone insubstantial ones.
Sorry, Justice Turon, are you finished? Mr. Nkutova, as I recall it, the jurisprudence of the appellate division and then the SCA prior to the interests of justice factor being grafted onto the requirements for appealability was that the reason why they refused to hear certain appeals despite leave granted by the High Court was that the decision which it was sought to appeal against did not qualify, did not constitute an order or judgment within the meaning of the statute which gave the SCA the jurisdiction to hear appeals. It can only hear appeals against a, let's call it an order. And they said, well, an order has certain attributes, and if it's not an order, we don't have jurisdiction to hear the appeal. Is that broadly correct?
Yes, that's as versus Zweni, and repeated recently in SIPLA.
Yes. So when in those circumstances the AD struck the matter off the roll, it wasn't, as it were, disagreeing. It was simply saying we don't have jurisdiction. And it must be for that the appellate division or the SCA to decide whether they have jurisdiction to hear an appeal. And it must qualify as a decision. That was, let us call it the old law.
Yes.
Now, under the new law, the interests of justice, as I understand, it came into the Constitutional Court's test for leave to appeal by virtue of provisions which expressly relate only to the Constitutional Court, section 167. Yes. It was recognized by Judge Howie in the Western Areas case in the SCA. It says we must sometimes now realize that a decision may qualify as a decision for purposes of appealability, even if it doesn't have all the Zwane attributes, if it's in the interests of justice.
Yes.
But it still remains a question, doesn't it, of the SCA's jurisdiction. It only has jurisdiction to hear an appeal against a decision. I think the word in section 16 of the Superior Courts Act is now the word decision.
Yes.
And a decision is either an order with the Zwane attributes or an order which is perhaps missing some of those attributes, but where it is in the interests of justice to hear the appeal.
Yes, I mean, there are three.
Sorry, if I can just complete the, if that's been grafted on, and Judge Howie specifically said that that is how we must interpret the word, I think he was still dealing with the old act, the word decision or order.
Yes.
So applying that jurisprudence now, what the SCA does when it decides whether an appeal is properly before it is to ask whether the decision which it is sought to appeal against is a decision within the meaning of section 16. And surely the SCA gets to decide whether a matter is or is not within its jurisdiction to hear.
Yes. Well, what it does decide is whether or not the requirements of section 16A or B or C have been met. Now, that's where they say under 16.1A, an appeal against any decision of a division, and under section 16.1B, an appeal against any decision of a division. And then under section 16.1C, an appeal against any decision. So these are all appeals against decisions as opposed to appeals against orders. But decisions can take three forms. There could be an interlocutory decision, like striking a matter from the roll. There could also be an interim order, like we have in this instance. There could also be a final judgment, which will come in due course. But all of those are decisions. So the term decision is a much more expanded term. If it is not a decision as defined, then of course there is no jurisdiction to hear it. At least there is no appeal jurisdiction. The dispute we have in this case is that the SCA assumes, in fact, what it does is to lift the Zwane non-decision into the post-Superior Courts Act decision matrix, which expressly recognizes an interlocutory order is a decision, an interim order is a decision, a final order is a decision. And so this is why there is such glaring jurisprudential inconsistency in the judgment of the SCA, because it's basically grafted old law into the new framework. And that's why it makes no sense, because it has to lift interim orders from the realm of decision and then say practical effect, but that practical effect was Zwane on the basis that it was only responsible for judgments or orders, but not the wider remit of decision.
But isn't that the general, I mean, is it an objectionable jurisprudence to say in general, something doesn't qualify as a decision for purposes of section 16 unless it has the Zwane attributes? There are certain limited exceptions, the interests of justice, but we are still concerned with what the word decision means. Or is your argument now decision means everything, including a ruling to allow certain questions to be answered during the course of a trial?
Yes, what I'm suggesting is that jurisdiction for purposes of an appeal is interest of justice based, and questions of decisions are factors to be taken into account in exercising the interest of justice remit of the court. In other words, the court is no longer, as it were, bound by the line of Zwane, which basically performed a form of classification a priori. So what you did in the Zwane standard, you classify a decision first a priori, and that's height of formalism. And then thereafter, you decide whether I should hear the matter or not. What I'm suggesting is that the revolutionary impact of the Constitution and judgments like Justice Mogoeng's judgment on interest of justice is to widen the scope of inquiry for a judge so that the decision is not an a priori consideration, but it is a factor to be taken into account in the exercise of broad interest of justice considerations. And this is a crucial point because it widens the scope of inquiry of the SCA. And then it takes us away from the formalistic classification of the Zweni test. And that is where there is a total disjuncture in, if I can put it that way, in what in what the SCA majority has done. It's taken us back 35 years ago to Zweni. It's literally taken us back.
No, I understand that. My point is a more limited one. You put the question of interests of justice as to whether there were grounds for the SCA majority to interfere in the way the High Court had exercised its discretion or its value judgment on interests of justice. Whereas if it's a matter of jurisdiction and appealability, it may be for the SCA itself to assess the interests of justice test. It may still lead to the conclusion in this case that it was in the interests of justice to hear the case. I'm just questioning whether it's a matter of interference with the judicial discretion.
Yes, it is in two respects. I mean, firstly, the SCA just doesn't grasp the test, right? It still imposes an old test. So what we say, the test is wider. The SCA itself has recognized that the test is wider. And secondly, even if it got the test right, in fact, we know in this case it didn't get the test right. Once the judge of the High Court has anxiously considered the interest of justice issue and decided in those circumstances that let me grant leave to appeal, it's wrong for a court of appeal to just say, I'm just going to do what I want to do, and I will ignore what the High Court has done. It makes nonsense of that entire debate we had before the High Court. And it also makes nonsense, as the acting Chief Justice correctly points out. It also makes nonsense of the framework of Section 16, which is there is a clear framework about when will the SCA hear matters. It will hear the matters because there is an appeal directly to it, because it has been refused by the High Court, or because the High Court has said, we've looked at the matter, we think it must go to the Supreme Court of Appeal. But in those circumstances, to just revisit with no reason whatsoever given in the judgment, we say in those circumstances, it is a question, firstly, of not getting the test right, but it is also a question of an improper interference with discretion that has been properly exercised.
Thank you.
Mr. Nkatobi, may I take up two aspects, please? They are related to each other. The first is, when you read the majority judgment, there is reference to the interest of justice. Yes, but you say they just simply paid a mere lip service to it. I mean, from paragraphs 8 at page 423 onwards, they discuss the interest of justice test, Justice Sutherland. You say that's mere lip service.
No, that is lip service. It's quite clear that throughout the majority judgment, what they applied, I mean, we don't say that they didn't mention interest of justice. What we say, they just never applied the interest of justice standard. And it's clear from paragraph 12 throughout until the last paragraph 26, that what they were worried about is the finality of this order.
And then the second question, I found the approach of this court where Moseneke DCJ dealt with this question of Zweni and the evolvement subsequent to Zweni International Trade Administration Commission, quite instructive. And this ties into the debate you just had with my colleagues. Just from paragraphs 50 to 54 of International Trade Commission, Moseneke DCJ discusses Zweni and he says that after Zweni, the SCA has recognized that the general rule against piecemeal appeals could conflict with the interest of justice in a particular case. He then referenced Western areas which you've dealt with.
Yes.
And then he also refers to the SCA's approach itself, where Farlam JA applied that interest of justice test in Pilanima, Africa versus Mailula. Yes. In the end, what I think this court held in international trade is that the primary consideration is whether it's in the interest of justice for a litigant to be granted leave to appeal in respect of an interim order. Zweni plays some role, but surely it must take a backseat to the interest of justice in cases like this, where you are dealing with an interim order, which may in effect be final. But ultimately, that's not the test. It's the question of, is it the interest of justice, as I see it, as I read International Trade Commission, is it not so?
Yes, no, correct, Justice Machete. In fact, you're correct for another reason as well, which is that the primary factor is interest of justice. That's what gives jurisdiction to an appeal. The question as to whether or not the decision is final, in fact, is one of the factors that one takes into account in considering whether or not it's in the interest of justice. And the problem is the approach of the SCA that fixes upon, let's first decide, is it a final order? And then on that basis, well, it's not appealable. And then interests of justice are mentioned because they were argued, debated in full. And where you see that the issue of Mailula is mentioned at paragraph 24 of the SCA judgment, but look at how it's dealt with. They say these two cases dealt with the threat to evict the same body of persons and potentially render them homeless. In the first case, the Constitutional Court entertained the appeal against an order of eviction, which has been put into effect despite a pending appeal. And then they say in this court, look at page 434, in this court in Parliamentary Africa, the conclusion similarly was reached that in a case of eviction, an appeal against an interim order was indeed appropriate in the interest of justice. The underlying rationale of irreparable harm is plainly demonstrated in such cases. So the first problem with their treatment of Parliamentary Africa is to confine it to eviction cases. And then the second one is to suggest that in this case, there is no demonstrable irreparable harm. And you see this in paragraph 25. The endeavor of the appellants to persist in their efforts to appeal against the interim order is in truth an attempt to entice this court to decide issues which lie within the province of the trial court when determining final relief. I mean, that is just wrong, because the issue before them was, should the interim order have been granted pending the trial in circumstances where the issue was meant to be decided in the trial. Just like where they found that what they found at paragraph 22, but they said it was open for us if we could contrive some serious harm to invoke section 18.2 and section 18.3. I mean, the problem is self-evident. 18.2 and 18.3 apply only if the decision is appealable. They won't apply if the decision is not appealable. So there are also internal contradictions in the judgment of the SCA that just are inconsistent with the structure of the legislation.
Yes, I just want to conclude by saying that as a matter of interest, International Trade Commission specifically references Parliamentary Africa and the Mailula matter in discussing this question of the appealability of interim orders. And it's surprising that it was sought to be distinguished by the majority. Thank you.
Thank you.
Mr. Mugaitobi, we are at 11:45. That has given you about 40 minutes. Obviously, if colleagues also still have issues that they feel are important to put to you, bearing in mind that Mr. Mpofu is still going to come in, I will let them do that, but I'm letting everybody how much time we have spent.
I'm making one more sub point under point 3, and that will be in 1 minute. The one sub point that the SCA did not consider in directing us to go to Parliament.
Okay, Mr. I think Justice Mhlantla does have a question before you go to your sub point.
Thank you.
Just one question. I had two, but I think I can do without the one. I wanted to, just if we are with you, the respondent is saying because the SCA did not deal with the merits, the matter should actually go back to the SCA. Would you maybe address us on direct appeal? Because it would mean that you must then persuade us to hear the matter.
You know, Justice Mhlantla, I'm not sure if our learned friends are correct. I saw that paragraph in their heads. I'm not sure if that is correct. If, for instance, we had gone to the High Court and lost, and then gone to the SCA and got refused leave, the fact that you've gone back to the decision that actually there should be leave should have been granted by the SCA doesn't mean we must now go back to the SCA for so-called merits. We are properly within the jurisdiction of the Constitutional Court in the interest of justice. We've been to the SCA. It's effectively refused leave. That's where we are. It's SCA that has refused leave. The matter is now before the Constitutional Court in the interest of justice under Section 167 as an appeal against a decision of the Supreme Court of Appeal. So it's not as if there is anything that the SCA still needs to do on the matter. It's done its job. It's decided the matter shouldn't be heard. And the minority says the majority is wrong. So it's now within your jurisdiction as the Constitutional Court. So I think that the correct approach on this issue is if the SCA was wrong, there is nothing to be referred to them. The Constitutional Court has interest of justice jurisdiction because there are constitutional matters arising and there are matters of general public importance arising directly under Section 167 of the Constitution. And for those reasons, you've got to hear the case. There are also broader issues as well. You remember, Justin Clancy, this case came as a super urgent application before the High Court, super urgent application, which was then granted, I think, a day after the hearing. And then it took another 4 months before we got reasons. And then it took another 13 months before the leave to appeal was heard. And then we got struck in the SCA. So we are now here literally 3 years after the event. And in the meantime, when we go back to the Supreme Court of Appeal, the interdict continues to apply. And so it's not in the interest of justice to countenance that level of delay. Matter is before the court, it must be decided finally before the court. It's either Mr. Olumisa is entitled to say the things he said in that letter, or he's not entitled to say those things. And he cannot be subjected to a judicial rigmarole that requires him to go back to the SCA again to revisit an issue that the SCA had before it and it decided not to deal with it.
Thank you.
Thank you, Justice Mhlanga. The sub-point, Acting Chief Justice, is that if one looks at the judgment of the High Court, and you will see this at volume 4 at pages 369 to the judgment goes on to 387. What you will see most glaring is that although the authority in Leroux versus Day is cited, which is the first step is to give meaning to the words, the High Court, in fact, never gave any meaning to the words. It cited what Mr. Berger had submitted, but it never actually gave any meaning to the words. And secondly, it never actually stated which of those words in that letter were defamatory. So there is also just a failure to apply the test for the determination of whether or not a statement is defamatory. It is just nowhere in the judgment where it says, these are the statements we find defamatory. And there's nowhere in the judgment which says, this is the meaning of these statements. And that takes place in the context where Mr. Olumisa has shown in the answering affidavit that the underlying facts are true or substantially true, but he is then entitled to add his political flavor to those facts. Thank you, Acting Chief Justice. I have nothing useful to say to you anymore.
You are muted, ACJ.
Oh.
Okay, I'm sorry. Thank you. I wanted to say on a lighter note, Mr. Ngogaitobi, that I thought earlier on you said that the matter went to the SCA and the SCA refused to do their job. But I hear that you say the matter went to the SCA and they did their job. Now we must do our own.
Yes, indeed.
Mr. Pofu.
Thank you. Thank you, ACJ. ACJ, yes, mine was to deal with the merits, but I'm very tempted just for a minute to weigh in on this issue of appealability and jurisdiction.
Yeah.
My 2 cents worth of contribution is this, that the question that you have raised, ACJ, is very pertinent, but it also lies in a distinction that is not usually made between appealability as a distinct question and leave to appeal. Because that's where I think the problem is. To use Mr. Ngogaitobi's language, the High Court made 2 decisions. One was on appealability and the other one was on leave to appeal. And that's what you were talking about, ACJ, the right to appeal. It really relates to the second leg, which is the leave to appeal. Now, the problem we have here is that those decisions, capital letter D, have been made. And so surely the SCA cannot just deviate from those decisions just out of the blue without reasoning. In other words, without saying, well, the High Court was wrong on appealability because of this and that and the other, and it's also wrong on granting leave to appeal for this and that reason. Because obviously we know that the mere fact that something is appealable doesn't mean leave to appeal must be granted. And that distinction is made very clear in the case of National Commissioner of Police versus Gun Owners of South Africa, which referred to all these cases and Pilanima Africa. The following was said: what the interests of justice require depends on the facts of the particular case. This standard applies both to appealability and the grant of leave to appeal, no matter what pre-constitution common law impediments might exist. So that's the one answer. The other answer, very briefly, lies in what was said in Tshwane City, where after summarizing the Zweni approach, it then says all of this, I just don't have it in front of me, but that it says all of this is now subsumed under the interest of justice standard. So the issue really goes back to what it is. I'm of the view that the SCA certainly cannot simply ignore the decision, so to speak, of the High Court on appealability. But finally, on this, it must also be noted, ACJ, that this decision here was made not necessarily in terms of Section 17A1, which is the prospects of success. It was made under Section 17A Roman 2, which is that there are other compelling factors. And I would go further than Mr. Ngcukaitobi and say, in those circumstances where the decision is made under Section 17A Roman 2, which is vintage discretionary granting of leave to appeal, then surely the SCA can only interfere if it meets the standard of interference with discretions. Otherwise, it's completely barred from changing that decision. Now, thank you.
Thank you, Mr. Mpofu.
Thank you very much, ACJ. Now, coming to the merits, I will, because in the interest of time, I will take a shortcut. I was going to discuss this firstly, either in terms of just going through the requirements of interdict, but I choose to do it differently, ACJ, with the leave of the court. And yes. I'll do it like this. Taking advantage of the two minority judgments. One issue that everybody agrees on is that an interdict of this nature is not generally given. It's given, whether you call it a gagging order or whatever, those are just hyperbolic statements. But an interdict to curtail free speech is seldom granted. That's obvious. That comes from Higgs networks and all those cases. So if that's the starting point, then you have to say, what then are the exceptional circumstances in this case that would entitle the court to have granted this interdict? Let's park that thought. I'll come back to it. The second obvious matter that comes from cases such as Helbron, Herbal Zone, and so on, and MIDI, is this, and it's completely indisputable, that one of the tests to find out whether such an interdict should be granted or not is where there is no defense that has been offered. And the word no defense in this context has been clearly explained by our courts to mean a situation where it's not just an ipsa dixit. So the defendant shouldn't just say, well, I have a defense of truth and public benefit or fair comment or whatever. There must be more than that. There must be substantiation of those defenses. Once that happens, and this is for a very important reason, because it is said, I think it's in the herbal zone matter, that otherwise you would be curtailing lawful speech. And it's a crucial issue, because it's lawful either because there's a justification of whatever nature, or it's potentially lawful. And therefore, it's even now a double caution from interdicting it, because you're not only restricting your Section 16 rights, but you're actually now restricting speech that may be actually justifiable. Now, the most distinctive feature of this particular case is that both minority judgments state clearly, and the first one you'll find at paragraph 36 of the judgment, which is volume 5, page 440. And that will be the judgment of Mulimela J.A. She says very clearly that the appellants laid a factual foundation for a defense of truth and public interest in the answering affidavit. As to whether the defense is sustainable can only be established at the trial, which is the procedure elected by the respondents and so on. And then she says, the fact remains that on the correct application of the principles laid down by this court in Heilbronn versus Bliffnot, an interim order ought not be granted if a factual foundation of the defense of truth and public defense has been laid. If you go to page 450, paragraph 57, you'll find that Justice Mahoka makes the exact same point. He says, as stated above, the appellants rely on the defense of truth and public interest. The appellants do not merely content themselves with bold assertions in this regard. They set out facts from which the allegations can be deduced. I'll just stop there. So that means, and interestingly, the majority judgment is completely silent on this issue. It's not as if they differ and they say, no, it's just the ipsa dixit or it's a bear. They say absolutely nothing. So we have here a very simple case where the defense of truth and public benefit on the at least from the two minority judgments has been postulated. And according to all the authorities, that's a no-no, that's a red flag. Once we have that defense postulated by more than mere ipsa dixit, then you may not grant an order of this sort. But what is more, Acting Chief Justice, is that the real quotation from Herbal Zone, which is reproduced at paragraph 35 or page 440 of volume 4, says this interestingly. And this is the part that is mostly misunderstood, because people always go for the common law defenses, but those defenses, in my respectful submission, were used in that case just as examples, because the court said what is required is that a sustainable foundation be laid by way of evidence that a defense such as truth and public interest or fair comment is available to be pursued by the respondent. In other words, any defense, whether it's truth and public benefit or fair comment, if it's sustainable on the papers, is sufficient as a bar. Now, in this case, with respect, Acting Chief Justice and Justices, we have more than exceedingly surpassed that particular test. Why? Because not only have we, as the minority judgments have said, clearly said, have we brought up what I will call the common law defenses of truth and public benefit, but in addition, we have also pleaded constitutional defenses in addition, based on section, not just on section 16, on section 19 of the Constitution and section 58 of the Constitution. So here you even have a bonus more than the public. And remember, these constitutional defenses, let's take at random the section 58 one. The section 58 defense actually gives you what is called total immunity, total privilege, as opposed to what we normally call qualified privilege. If we are correct in the interpretation of the Dikoko case, as Mr. Ngogaitobi referred to, which went back to cases such as Puvalingam and those old defamation cases, then that immunity doesn't only operate in Parliament, but also even outside of Parliament. So forget truth and public benefit, forget fair comment. Let's assume that was the only defense we had. If the only defense was our section 58 defense, it would still constitute a bar, because the real mischief would be, are we here limiting speech that is otherwise lawful? And if it's lawful, whether it's lawful because of truth and public benefit, or because of fair comment, or because of section 58, or because of section 19 of the Constitution, it doesn't really matter. The point is this speech that is otherwise lawful, which may be gagged? And once you have, that's a red flag that says you may not then interdict it. And for the sake of completion, just to touch on the point that Mr. Ngogaitobi made, here we're also dealing with the section 19. We're not dealing with an ordinary appellant. We're dealing with a political party that has its own rights. That's the first appellant. It has its own rights in terms of section 19. And B, we're dealing with the second appellant, who is the president of that political party, who also has his own rights to propagate, to campaign, or whatever. So let's say, for example, Mr. Holomisa, one of the reasons why he raised this matter was just as a campaigning tool. We've just finished an election cycle. That means in that entire election cycle, he was gagged from using this particular revelation as a campaigning tool. And yet section 19 of the Constitution gives him that exact right. So there can be no doubt. Yes, Justice Theron?
I'm sorry to interrupt you, but I want to go to the defense that appears to be raised about truthfulness. And if I can refer you to paragraph 56 of the respondent's answering affidavit, which appears at page 148 of the record.
148, I've got it.
In volume 2. I must say, I'm slightly confused. If you look at the second line, the third sentence, it says, it must be recalled that this case is not about the truthfulness of the allegations, but simply whether a prima facie case of wrongdoing is established that will justify an investigation.
Yes. Yes, no, I see that, Justice Theron. I think it was one of those urgent drafting. The word that's missing is probably merely. It's not merely about the truthfulness of the allegations. In other words, that is the point that I was just making, that it's not merely whether, for example, the money was stolen or not, but whether there is a justification, a defense. Let's use that word here. Whether there's
can the applicant go that route when on its papers the applicant says this case is not about the truthfulness of the allegations? Can the applicant raise the defense of truth?
No. Well, unfortunately, Justice Theron, one would have to look at the pleadings as a whole. You can't, if you as I say, if there's just that one missing word, and if you say nowhere in the reply, in the answering affidavit, do we actually say that Mr. Muleketi, for example, was indeed a deputy minister, who was the chair of the PIC, who benefited, these are all common cause facts, which benefited from PIC funds, rightly or wrongly, but these are true allegations which are not denied. That Mr. Maxwell,
if I can then take you to paragraph 60.
60, yes, I'm there.
At page 150. In a similar vein, also dealing with whether these statements are true or not. You look at the last sentence, it says, if after the investigation, it turns out that the allegations were inaccurate. What the drafter is saying, or the deponent is saying, I don't know if those allegations are true or not. We want it to be investigated. In those circumstances, can the applicant rely on the defense of truth?
Well, the issue is twofold, Justice Theron. One, of course, the gravamen of the letter is to call for an investigation. But what we're saying is that at least the underlying facts are common cause and true. And those, just those facts that are common cause and true are sufficient in our respectful submission to at least invoke the Section 58 defense, for example.
I'm sorry to interrupt you, but if we look carefully at what paragraph 6 says, that's not 60. That's not how I read it, Mr. Mpofu. It says, if after the investigation, it turns out that the allegations were inaccurate, it doesn't say that the underlying facts were true. That will mean that there was no basis to the investigation in the first place.
Well, it doesn't. I'm afraid, Justice Theron, if means 50-50. It doesn't mean it's untrue. It means if it turns out to be untrue, that doesn't mean it's untrue now. It may well, after the investigation, turn out to be true. So it's, at least as we stand here, it's 50-50. I think it would be reading too much if we said if than if we said since. Let's say if we said since the allegations are untrue, that would be a different matter.
But surely in a defense of truth, the party must be able to say the statements that I have made are true and correct.
Well, if that was the case, then Justice Theron, then there'll be no need for the trial. Remember, we're at an interim stage here, and that is exactly what the the SCA said in Tau, which is that the postulation that I gave earlier about no defense versus a defense that is substantiated must never be elevated to the level that we are now debating, of saying that at paragraph 25 of the Tau case, for example, this is what is said after having postulated that the defense might be sustainable. Says this obviously is not to say that the appellant's defense of justification is likely to succeed in the defamation action, which is pending. So that's exactly the same as paragraph 60. It is not to say that the truthfulness is going to be established. They say that is an issue. That's what Skipper's JA said. That is an issue to be decided by the trial court. But where a factual foundation for a defense of justification has been set up in motion proceedings, a court cannot know whether defamation has been proved until the trial process has shown where the truth lies. In other words, where the truth actually lies will only be shown at the trial, not now, not at this stage.
I just have one last question on this aspect.
Yes.
And I have a further question, Mr. Mpofu. If you look at paragraph 6.2 and paragraph 7 of the letter.
So, yes.
Yes, allegations are made, but it seems to me, unless I'm missing something, these allegations are not expounded upon in the answering affidavit. The facts to support these allegations are not given in the answering affidavit, unless I'm missing something. For example, in paragraph 7, the letter says that the individual respondents, and I quote, are double or triple dipping in the PIC's funds, and that they have conduits at their disposal to sap PIC funds. Now, where in the answering affidavit are the facts put before us to demonstrate the truth of those allegations?
Okay, Justice Theron, let me just say this, and it goes back to what I was saying when I was tabulating the common cause facts. We know, and it's undisputed, that Mr. Muleketi was the chairperson of the PIC. It's accepted by everybody. We also know that Mr. Mahluele, who's the fifth respondent, was a senior executive in the PIC, the common cause. Fast forward to where we are now. We know that their company, Hareth, has benefited from PIC funds, common cause. Now, the only question that, and that's a yellow flag, so to speak. Now, all that is being suggested is that there has been a breach of, in the case of Mr. Mahluele, of just the normal conflict of interest provisions. But more seriously, in the case,
Mr. Mpofu, isn't that somewhat of a quantum leap without any facts to draw that conclusion or suggest that conclusion? Isn't that somewhat of a quantum leap?
Well, Justice Theron, maybe let me start with the easier one. It can never be a quantum leap in the case of a former member of a deputy minister who is squarely covered by Section 96 of the Constitution as a person who, among other things, must always avoid any risk or perception of a conflict. And if I'm a minister of water affairs, and then next month, and I'm exaggerating for effect, next month, I'm no longer the minister of water affairs, but suddenly I come up as the shareholder in a water company. Surely, that must at the very least raise the issue of a Section 96 breach, or the so-called Javelin method of corruption, which is that we all know some people javelin the corruption and then come out and say, oh, well, I'm no longer a minister, but you've already done all the favors while you were still a minister. So it's not a quantum leap with respect, Justice Theron. It is something that at the minimum calls for an explanation. There might well be an explanation. It might be complete coincidence. And that's what we try to say at paragraph 60. It might well be that this is a pure coincidence, but surely nobody who lives in South Africa can say that a minister of minerals, who suddenly is a mine owner a week after losing their job, is not, it has no case to answer of having.
If I could please just bring us back to this case.
Right.
And the letter says, unmasking alleged fleecing. The letter doesn't speak to a conflict of interest. The words used are clear. It's fleecing.
Yes, well, the javelin to sit in an executive position and then the following week benefit from that is fleecing. Actually, that's an understatement. It's corruption. There's no doubt about it. It's not a mere. You can't just make billions or millions or whatever, or even hundreds of thousands from the very position that you held in government. That's fleecing the public, I'm afraid.
And then in paragraph 1, it says that could potentially make the Gupta family's alleged capital of state look like chump change.
Yes, it would, because
where are the facts, Mr. Mpofu, in support of that?
Well, the facts, Justice Theron, are the ones that I've presented. It is a fact that he was the chairperson of the PIC. It is a fact that he subsequently benefited from the PIC. It's a fact. It's a fact that he was the chair of that board. So these are not. It's not speculation. It's a fact.
I've heard you on that, Mr. Mpofu. I have a final question. If I understand the argument correctly that's being presented today, the applicants are relying on privilege. Was this raised in the High Court? Has it been raised in the papers?
Yes, it was raised in the High Court. That is why Justice Kapi referred to it. Justice Kapi, there were 4 sections really, and 2 of them we've just dealt with now, that were invoked of the Constitution. It was Section 16, the usual, Section 19 of the Constitution, Section 58, and Section 96 that we've just discussed now. So those were the 4, 16, 19, 58, and 96. Those were the, and in fairness to Justice Kapi, she, in granting leave, she specifically referred to this question of the Section 19 rights. Because, Justice Theron, just to finish, let's assume, for example, that I'm wrong completely on truth and public benefit, on anything else. Then that's the point I was making. It remains a fact that we would have a viable defense. And I'm just using that to paraphrase what the case is saying. That would have a viable defense based on Section 58 and Section 19 and Section 96. Why? Because this particular appellant, unlike you and I, has there's extra rights imposed by the Constitution under Section 16. Both appellants, both the first appellant and the second appellant, separately. The political party, qua political party, has its own rights, but the MP, the member of parliament, qua member MP, has rights under Section 19 and under Section 58, and one of those is a total privilege, total immunity to repeat the statements both inside and outside of parliament. But that's not today, is not the day for that debate. But it raises another question, with the greatest respect, of the brutum fulmen that Justice Mahoka spoke about. Because if indeed Mr. Olomisa has a right to repeat these statements, let's just say that right is confined to Parliament to avoid the other debate, then what is the point of this interim interdict? How can you say there's a balance of convenience in favor of granting it when the person can actually go tomorrow and repeat it 100 times, and the next day, and the next day, and the next day? It's even at the pure level of the requirements of interdict, which, as I said to the ACJ earlier, I was going to approach the matter from that point of view. It's a meaningless interdict. So you take the price of gagging somebody, given the exceptionality of these orders, against what? Against a useless order of restricting something that is unrestrictable, so to speak. It would even be worse.
Thank you, ACJ.
Thank you very much.
We are at 11:20. I just want to remind everybody, in terms of the legal teams, that you can proceed on the basis that we are quite familiar with your extensive written submissions on both sides. So you don't need to address everything. And unless you say so yourself, we won't assume you to have abandoned any point that you have included in your written submissions. So I just want to mention that. Mr. Mpofu?
Yes, ACJ.
Yes.
With that assurance, then I'm really going to wrap up in a few minutes.
Yes, please. Okay.
Yes.
Thank you. Thank you.
Thank you. And the point I just want to make these crisp points, or to re-articulate them with the debate that I've had both with yourself and Justice Theron. One, we all accept that these are not orders that are granted without, or are only granted only in exceptional circumstances. Two, we all also accept that the test, as I've already articulated, is whether there is no viable defense that has been pleaded, which may or may not fail in the trial, but whether it's viable or not. And my punchline is the following, that in this particular case, not only do we have we pleaded viable common law defenses, which we have just discussed now with Justice Theron, but in addition, we have pleaded constitutional defenses, which are suited for this particular case because of the facts. And it's common cause on anybody's test that these issues are context specific and so on. So what is the context here? The context here is that the alleged defamer is a political party and a president of a political party. So they have more rights, using those words loosely, than our normal section 16 rights, which all of us have. So on top of that, they have section 19 rights, which I've articulated, and on top of that, even worse, they have section 15(8) immunity. So that goes, it's a triple insurance against any accusation that there's no viable defense in this case. And my mere submission is that in the presence of a viable defense, given the cases of Hilbron, Hicks, and all those other cases, and Dow in particular, then it cannot be said. And paragraph 25 of Dow makes it clear that those defenses need not be so super that you can almost say they're going to succeed in the trial. They may fail, but the question is whether they have been pleaded. And on that basis, therefore, if the application, or rather, if the matter is appealable, as we submit that it is, then even on that basis, the appeal should be granted. And then add to that one more point, DCJ, which is that forget about everything I've said. If you just go to the good old Sitlugelo test, can you say then under all these circumstances that there's irreparable harm to be suffered by the other side, that there's no alternative remedy, and particularly that the balance of convenience favored the granting? No, I'm prepared to concede the first requirement, which is a prima facie right, because they have a right to dignity and so on. We accept that. But the other three elements, just often interdict in these circumstances, have simply not been met. As the court pleases.
DCJ, may I raise one short aspect with Mr. Mpofu, please?
Yes,
Mr. Mpofu,
yes.
extensive reference is made in your written submissions to the findings of the party commission. You accept that that's irrelevant and inadmissible in these proceedings because it was never before the High Court and the SCA.
Well, yes, we accept that as a general answer, but to a limited extent, it's in the SCA judgment. You'll notice that there's actual reference to the following fact, and if you limit it to that these allegations were of such a serious nature that it prompted the president of the country to institute a commission, or maybe that's overstating it. At the very least, to include these issues in the terms of reference. Remember, the original request was that this should be put into the so-called State Capture Commission, and but
yes.
It's only relevant to that extent. Yes. But I accept, Justice Machid, that the actual content of that report would be irrelevant.
And related to that, you accept that neither the UDM nor Mr. Olomisa are whistleblowers. The allegations come from unnamed whistleblowers, and therefore the veracity of those allegations come from have to be sourced from whistleblowers, these unnamed whistleblowers. Do you accept that as well?
Not really, Justice Machida. I think that would be really putting a fine-tooth comb. The real issue is that the source of these allegations are whistleblowers. And to the extent that we all accept under the constitutional principle of accountability that whistleblower originated information must be protected, then it's relevant. The fact that Mr. Holomisa might be a conveyor of a whistleblowing information doesn't make him less of a whistleblower to the extent that he was the vehicle to bring this, to put the spotlight. Remember, the real purpose of whistleblowing is to put literally spotlight on corruption. And one can say, roughly speaking, Mr. Holomisa and the whistleblower put the spotlight and the court has switched it off, basically, or this order.
Yes, thank you. Thank you, ACJ. Thank you.
Thank you, Justice.
Thank you very much. We are at 28 minutes past 11. I think we should take the tea break and resume at 11:45. We'll adjourn.
Thank you, Scott. Please, ACJ.
We'll adjourn until 11:45. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:45. Should you exit, you may use the same link to rejoin the hearing.
It's fighting. Yeah, no, but don't.
No, thanks. No, I think there's no. I think only the good things and that's why.
I went out, hello, how are you? Yeah. But you won't be able to
Are we all back?
Yes, we're back on our side, ACJ.
Yes, thank you. Thank you.
Thank you, ACJ. We're also back.
Yes, okay, all right. Are my colleagues all back?
I don't see Justice Madlanga, ACJ.
You don't see him?
Just Ron,
He's
Justice
there.
Ron, I was actually the first one to switch
Oh.
on.
My apologies, Justice Madlanga.
Okay, okay. I think then we can resume. Okay, Mr. Becker.
Thank you, Acting Chief Justice. ACJ and Justices of the Court, I have four main topics that I wish to address. I take the ACJ's warning that you've read our heads of argument, but there are four main topics. The first is the jurisdiction of this court, and it's the jurisdiction to set aside the order of the SCA. That's the jurisdiction with respect that we're talking about. The second is, if the court has jurisdiction, then whether the majority judgment in the SCA is correct. The third topic that I wish to address, and that's very briefly, is the issue of the direct appeal on the merits. And we only raise that just as a point. We don't pursue it strongly, that third point. It's just that this court, with respect, must just consciously decide to forego a judgment on the merits from the SCA. And then the fourth point is the merits of the High Court application for interim relief.
Yes.
So if I can go back to the jurisdiction of the court, our first main submission is that the court does not have such jurisdiction because the application for leave to appeal does not raise constitutional issues. This court, for more than 20 years, has held that constitutional matters are only those that raise substantial constitutional issues for the court to grapple with. And our submission is that this case fundamentally is about the SCA exercising its inherent power in terms of Section 173 of the Constitution to protect and regulate its own process. We say that if the case is viewed from the point of view of Section 173 of the Constitution, that there are no constitutional matters that arise. Simply because the applicants say that sections 16, 19, 58, and 96 are implicated doesn't make it so. And I refer to the earlier judgment of Justice Madlanga in, I think it's in Bata, where Justice Madlanga said, just because, and it's not Justice Madlanga alone, just because an applicant says the case is about a particular section of the Constitution doesn't make it so. Our second submission is that the SCA's exercise of its inherent jurisdiction does not raise an arguable point of law of general public importance, which ought to be considered by this court. The applicants we submit must show that they have an arguable point of law relating specifically to the SCA's power to set aside the order of the High Court granting leave. That's the arguable point. We say that there's no argument of any substance on this point. As the applicants pointed out in their founding affidavit in this court and in their heads of argument in this court, The SCA has been doing this for more than a century. And we've also set out the case law or some of the cases in our heads. The SCA has been protecting and regulating its own process for more than a century. And if it were not able to do so, the SCA would be swamped with countless matters that should not be on the SCA's role. And we mention a few, for example, Hamilton, the case of Hamilton in 2001 and Swart in 2016. Swart is cited in our heads at footnote 14, where Matopo JA bemoaned the fact that unworthy appeals are referred to the SCA. Not appeals where the High Court judge misdirected himself or herself, but unworthy appeals which in the view of the SCA are unworthy. Our submission is that the two minority judgments in the SCA in this case are with respect clearly wrong. They are based on two cases of this court, National Coalition and Trencon, but the paragraphs relied upon in both National Coalition and Trencon do not provide authority for the points of view taken by the minority judges in the SCA. I'll elaborate on that in a moment. But
I'm sorry, Mr. Becker. I don't know whether it's something that I have done or something that Justice Theron has done or somebody else, but she's the one that I see on the big screen and I don't see counsel anymore at all. I would like to be able to see counsel. So I don't know if I've done something wrong. Probably Justice Theron would know better than me what has happened. Justice Theron, are you able to say?
Yes, if you can click on view, please, the top right-hand corner of your screen.
Yeah.
Click on view.
Yeah, and speaker.
Either if you click on the speaker, you'll see only the counsel who was addressing. If you click on gallery, you might see all of the colleagues.
Okay. Okay, all right. Okay, thank you. Thank you very much. Okay.
It's a pleasure, ACJ.
Yes. Thank you, Mr. Becker. I'm sorry I interrupted you.
I must also thank Justice Theron, because I've now just clicked on gallery and now I can see the whole
court. Yes.
The point that I was making, ACJ, is that, and this is a point that wasn't touched upon by our learned friends in their arguments, and that is, this goes to the distinction between the exercise of a discretion in the loose sense, such as the granting of leave to appeal, where an appeal court can substitute its own decision for the decision of the lower court. In contrast that against the exercise of a discretion in the true sense, such as, for example, the refusal of a postponement, where an appeal court may only interfere after having found that the lower court did not act judicially. This distinction between the exercise of a discretion in the loose sense and in the true sense was authoritatively settled by this court in the Trencon matter in 2015. We submit that it is clear that the decision of a court granting leave to appeal involves the exercise of a discretion in the loose sense. This court held in Trencon, following the decision of the SCA in Knox Darcy, that what this means is no more than that the court is entitled to have regard to a number of disparate and incommensurable features in coming to a decision. Now, we know that all superior courts are required to apply the provisions of Section 17(1) of the Superior Courts Act in deciding whether or not to grant leave. Clearly, in our submission, this is not the exercise of a discretion in the true sense. This court has already had occasion to consider the nature of the discretion involved in the decision to grant or refuse leave to this court, and I'm referring to the decision in State versus Busak in 2001. And clearly one can see, particularly at paragraph 12 of the Busak judgment, that the decision whether or not to grant leave to appeal involves the exercise of a loose discretion. And our submission is that the nature of the discretion exercised by the High Court is no different. And that is because the court, in granting leave or in assessing whether leave should be granted, has to take into account a number of disparate facts. And it's not the final decision where you can say that the decision is you could either grant or not grant. It doesn't really make a difference. For example, as in the case of a postponement, here the assessment of the factors will eventually conduce towards a decision whether leave should be granted or not granted, and it's therefore open to a court of appeal to reassess whether that decision was exercised. When that decision was exercised in the loose sense, to put its own view and substitute its own view as to whether or not the matter is appealable. The second point that we wish to make in this submission is that the applicants have not clearly identified what it is that makes this point one of general public importance. Our courts grant and refuse leave all the time. And as long as our courts apply the correct test, our submission is that no one will legitimately complain. As this court held in Paulson in 2015, for a matter to be of general public importance, it must transcend the narrow interest of the litigants and implicate the interest of a significant part of the general public. We didn't hear anything from our learned friends as to why this argument about the power of the Supreme Court of Appeal to substitute its own view for the appealability of a matter, why is that a matter of general public importance? And finally, we argue that it is not in the interests of justice. This is under my overview of the jurisdiction point. It is not in the interest of justice for this court to assume jurisdiction in terms of section 167 3B2. There are a number of factors why we say it's not in the interest of justice for the court to assume jurisdiction. The first is that the letter written by the applicants to the president has been published to the whole world. There are eight reasons I want to just go through very briefly. The second is that the letter is clearly defamatory of the respondents. The third, the declared purpose of the letter has been met. The fourth, and it's a point that my learned friend, Mr. Ngukai Toby, made, we say the applicants could have applied in terms of section 18.3 of the Superior Courts Act for a suspension of the interim order if they could prove irreparable harm on their side, and of course the absence of irreparable harm on our side, but they didn't do so. And I'll go there in a moment or later, but the wording of section 18.2 and 3 of the Superior Courts Act doesn't support the argument that our learned friend made. And number 5, the applicants have clearly not suffered any irreparable harm as a result of the interim order. 6, the applicants have remained free to repeat the defamation within Parliament, but they haven't done so. 7, the appeal would render nugatory the balance of convenience determined by CLAPJ. And finally, the civil trial, the civil defamation trial, starts in the High Court in Pretoria on Monday next week. However,
your 10 minutes of address without interruption is up, Mr. Baker, but you may proceed.
Thank you, ACJ. If the court is against us and finds that it does have jurisdiction to decide the matters, then the next question is, was the SCA indeed correct in striking the appeal from its role? If you look at our learned friends' heads of argument, and you look at the founding affidavit in this court, the submission and the point and the argument is clearly made that the SCA has no power, and that to reconsider the decision of the High Court granting leave, and that the practice of the SCA over the past century or so is actually inconsistent with the Constitution, inconsistent with the powers that the Supreme Court of Appeal has, and it is that practice which has to be brought to an end. But the argument in this court today was a different one. I'll come to our learned friends' argument in a moment. The point I want to make now is that even the minority judgments in the SCA do not say that the SCA is bound by the decision of the High Court. But the minority judgments proceed from the premise that the SCA can only overturn the decision granting leave when they come to the conclusion that the exercise of the trial court was not judicially made. We submit that that's clearly wrong. Our learned friend says that the majority judgment is incorrect because the majority judges applied the wrong test. Our submission is that this is manifestly not so. If one looks at the judgment of Sutherland AJA, one can see that it deals comprehensively with the applicable test for leave to appeal. The judgment goes to great lengths to set out the appropriate test. It cites the international trade case of 2010, that's also known as SCORE, National Treasury and Outer of 2012, and Tswane and AfriForum of 2016. And it's also clear from the extract cited by Sutherland AJA that the SCA has, in fact, been applying the correct test for more than a decade already. Indeed, as Moseneke DCJ stated in SCORE, and I'm quoting from paragraph 53, where the learned Deputy Chief Justice said, as we have seen, the Supreme Court of Appeal has adapted the general principles on the appealability of interim orders. In my respectful view, correctly so, to accord with the equitable and the more context-sensitive standards of the interest of justice favored by our Constitution. So there's no arguable point about this. The SCA has, for more than a decade now, been applying the correct test, which is that the operative test, the overarching test, is the interest of justice test. But as I shall demonstrate, part of that test incorporates the old Zweni test. And this is what the majority judges set out in the judgment, that Zweni still remains part of the test. And indeed,
Mr. Berger, as I understand it, I think the applicant's complaint is this. Sutherland AJA deals with the outer test and does so, one might add, fairly well with respect, but complained the applicants. He then completely closes that chapter and focuses on the Zweni judgment and the Zweni judgment only. That is the substance of the complaint. I do not understand the applicants to be saying that Zweni has become irrelevant. comment on that?
Yes, Justice Madlanga. In fact, the Zweni test must still be a relevant test when coming to the conclusion whether it would be in the interest of justice to allow an appeal or not to allow an appeal. Because if the order is not final in effect, if it doesn't dispose of a substantial portion, if it's not definitive of rights, then it would be difficult to argue that it would be in the interest of justice to allow an appeal. But yes, that's not determinative of the final question. But Justice Sutherland does not, as it were, pay lip service to the interest of justice test, and then having quoted it in extension, put it to a side, and then only apply the Zweni test. And I can point the court to a couple of paragraphs. The first thing is right at the beginning of the judgment at page 419 in volume 5. Justice Sutherland says the crux of the controversy is whether the order was final in effect and was therefore indeed appealable, or even if its true character was interim, the interests of justice warranted an appeal against it to be entertained. So that's right at the start. Justice Sutherland sets out the correct test. In paragraph 4, Justice Sutherland quotes extensively from the judgment of Klapi J, granting leave to appeal, where Klapi J discusses, in fact, says that there are no prospects of success on appeal, which is another interesting point, but she questions whether or not it's nevertheless in the interest of justice. Also goes into Tshwane City and Outer. And Justice Sutherland quotes the part of the judgment where Justice Klapi says that it is in the interest of justice that leave be granted, where it is contended that the interim order affects the rights of parties such as the applicant to engage in political activity. So it's very clear from what Justice Sutherland has quoted, and it's clear from the order granting leave in the High Court, that the one point, the only point that Justice Klapi relied upon to grant leave was this question about the Section 19 political activity argument. So that is identified by Justice Sutherland. Justice Sutherland then goes on to discuss Section 17.1 of the Superior Courts Act, and in paragraph 7 deals with the law on appealability. I won't repeat that. Paragraph 8 as well. Paragraph 9 is international trade, where Moseneke DCJ said the jurisprudence restated in Zweni remains an important consideration in assessing where the interests of justice lie. The SCA has held that the Zweni principles are not cast in stone and that the interests of justice are paramount. And then there's reference to the judgment in Western areas and Pilanima Africa in 2009. Justice Sutherland goes through Mashele versus Mailula, and then in paragraph 10 says, applying these norms, and if I can just go to paragraph 10 of the judgment, it's at page 426 of the judgment. Applying these norms to the facts relevant to the order in this matter, it may be asked, how might the interests of justice be thwarted if the interim order stands until trial and potentially is then held to have been inappropriate because either there was no defamation after all, or that the appellant's conduct is held to be justifiable? So that is, having gone through the law, that is the applicable test. One of the factors or one of the things that the court has to then determine, is this order of the High Court final in effect? Because Justice Madlanga, if it is final in effect, that would be the end of the debate. If it's final in effect, it's then appealable. So that's why Justice Sutherland spends time on Zweni and comes to the conclusion in paragraph 12 that the order of Clerk PJ cannot be interpreted as having final effect. So that's Zweni then out of the way. Then there's discussion on Tau versus Mashaba in paragraphs 13 to 16 and why that's not relevant. Paragraph 17, back to the order of Clerk PJ. Paragraph 18, a discussion of the arguments raised by the applicants in the High Court application for leave to appeal. There were a number of arguments. There's the Section 19 argument and all the other constitutional arguments that they raise. Paragraph 22, Justice Sutherland. So now, by the way, Justice Matlanga, you can see that Justice Sutherland has finished with Zweni and is now dealing with other factors which are raised, which are contended affect the interests of justice, because this has got nothing to do with Zweni anymore. And in paragraph 22 of the judgment, Justice Sutherland says, this is at page 432, he says it was suggested that the appellants could have invoked sections 18.2 and 18.3 of the Superior Courts Act, which is what we had submitted. And Justice Sutherland comes to the conclusion that we are correct, that they could have invoked section 18.2 and 18.3. And perhaps I should pause there because I may not come back to this, to look at 18.2 and 18.3. Our learned friend says that 18.2 and 18.3 are not applicable because it only applies to matters that are truly appealable. But that's not what the section says. Section 18.2 says, subject to subsection 3, unless the court under exceptional circumstances orders otherwise, the operation and execution of a decision that is interlocutory not having the effect of a final judgment, which is the subject of an application for leave to appeal or an appeal, is not suspended pending the decision of the application or appeal. And then 18.3 says a court may only order otherwise as contemplated in 1 or 2 if the party who applied to the court to order otherwise in addition proves on a balance of probabilities that he or she will suffer irreparable harm if the court does not so order, and that the other party will not suffer irreparable harm if the court so orders. So once there's an application for leave to appeal against a judgment, for example, of the High Court, such as the judgment of Clerk PJ, then it is open, because there's that application for leave to appeal, it is open to the applicants to approach the court under sections 18.2 and 18.3 with an application to say, we will suffer irreparable harm, they will not suffer irreparable harm, and therefore the judgment should be suspended. Justice Sutherland deals with that in paragraph 22 of the judgment. Then in 23, Justice Sutherland starts dealing with some of the other arguments, for example, the section 58 argument, and says that the appellants can repeat the allegations in Parliament in terms of section 58. But he says that this is no answer as to why a temporary silence outside Parliament is irreparable. The appellants do not make a case that the UDM is a one-issue party. Our learned friends have now referred to the case of this court in Dikoko versus Mokhatla, but and that's in 2006, volume 6, SA 235. But the judgment of Mohoro J doesn't say what our learned friend, Mr. Ngukai has said. I'm just going to refer to paragraphs 35 to 39. In fact, it's from 34 to 39 of the judgment. And Justice Mohoro there refers to some Canadian judgments, which might be helpful, and says in paragraph 36 that in Roman Corp, the court held that the object of privilege was not to further the selfish interests of the members of Parliament. It was to protect them from harassment inside and outside of the House when they carry out the legitimate business of the House. So when you're carrying out the legitimate business of the House, it may be that you may have some protection. But then at the end of this quote in paragraph 39, Mohoro J says, to determine the questions requires a consideration of the purpose of the privilege in a constitutional democracy. Immunizing the conduct of members from criminal and civil liability during council deliberations is the bulwark of democracy. It promotes freedom of speech and expression. It encourages democracy and full and effective deliberation, which is all true. It removes the fear of repercussion for what is said. This advances effective democratic government. There is therefore much to be said for a conclusion that if a councillor participates in the genuine and legitimate functions or business of council, whether inside or outside of council, the privilege afforded under Section 28 ought to extend to him or her. It says 20. For the reasons stated below, however, it is not necessary to determine that question in this case. It was a different section, but so that is what Justice Mohoro says in that case. There is no finding of this court that even suggests that Section 58 could be interpreted as applying both inside and outside Parliament. Again, I'll come back to that. Coming back to the judgment of Sutherland J, I'm almost at the end. There's a reference to the cases of Mashele versus Mailula and Pilanima Africa versus Mailula, where both cases dealt with the same body of persons, says Sutherland AJA. Irreparable harm was demonstrated in both cases. Both courts, that's the SCA and this court, allowed an appeal against the interim order. So Justice Sutherland has long left Zweni behind, has gone through all the factors which might possibly be relevant to an assessment of the interests of justice, including Zweni, and comes to the conclusion in paragraph 25 that the appellants want the SCA to decide issues that lie within the province of the trial court. In other words, the SCA can't finally determine the Section 19 argument or any other argument, because that is the argument that's going to have to be determined by the trial court. The conclusion in paragraph 26, the SCA says the order is interim in effect and the interests of justice do not require an appeal, and therefore the order is not appealable. So it's astounding to hear a submission that the Sutherland AJA and the majority judges just gave lip service to the interests of justice test. The judgment of the Supreme Court of Appeal, the majority judgment, is replete with considerations which go to the interests of justice. And so our submission is that the SCA, number one, applied the correct test, set out the correct test, articulated the correct test, and number two, applied the correct test. And in those circumstances where the Supreme Court of Appeal has applied a constitutionally compliant test, this court has said many times that it is not for this court to second guess the SCA. It doesn't give this court the jurisdiction to, in fact, reconsider the conclusion of the SCA where the SCA has applied the correct test, which is constitutionally compliant.
Mr. Berger, can I ask you, what do you say of the submission of the applicants that the granting of leave to appeal by Klapi J involves the exercise of a discretion by the learned judge, and that the SCA majority nowhere engaged with that exercise in finding that the matter is not appealable?
Justice Majid, that all depends on whether you see the exercise of discretion as an exercise in the loose sense or an exercise of discretion in the true sense. If, as we submit, and it is clear, we think, that the exercise of discretion in granting or refusing leave is an exercise of a discretion in the loose sense, then the Court of Appeal does not have to engage with the underlying judgment if it is of the view that the underlying judgment is wrong. The judgment of Tlhapi J came to the conclusion that the matter is appealable, not because there are prospects of success, but because there might be something in the Section 19 argument. Justice Sutherland rejected the Section 19 argument as a basis for leave to appeal. So our submission is that the Supreme Court of Appeal in the majority judgment makes it quite clear why it is that they are substituting their view for the view of Justice Tlhapi. And that is because the Section 19 argument is a non-starter. There's nothing else that Justice Tlhapi based her judgment on. And after an extensive analysis of all the factors that may be taken into account in the interest of justice, the Supreme Court of Appeal comes to the conclusion that it is not in the interest of justice that leave to appeal be granted. And then to pick up a point that Justice Rogers made when our learned friends was arguing, that then for the Supreme Court of Appeal is the end of the matter, because the Supreme Court of Appeal then does not have jurisdiction if the Supreme Court of Appeal comes to the conclusion that the matter is not appealable. It's not appealable on the Zweni test. It's not appealable on the interests of justice test. And therefore, the Supreme Court of Appeal has no option but to substitute its decision for that of the High Court and find that the matter is not appealable. And then, having found that, strike the matter from the roll.
Mr. Berger,
Yes, thank you.
What words in the Superior Courts Act, if any, do you interpret in coming to the conclusion that the SCA forms and can form its own view on the interests of justice?
Well,
just to highlight the distinction, if it's for the High Court to determine and grant leave to appeal, but you say the Supreme Court of Appeal can nevertheless decline jurisdiction in terms of its inherent jurisdiction, then that's a constitutional power. It's no longer an appealability point. The appeal is, as it were, properly before the SCA, but it exercises an inherent jurisdiction to decline to deal with it, which seems to be inconsistent with Sutherland AJA's judgment in the bank case, where he said the court doesn't have a roving jurisdiction to refuse to hear matters within its jurisdiction. So I'd be interested to know if you say that the SCA's right to determine appealability flows from the interpretation of any particular words in the Superior Courts Act.
Well, the Superior Courts Act, one has to start with Section 17. Well, actually, with Section 16. And there's the, I'm looking for it now, but no, I've got it here. I've got it. Yeah. I think it's 16.2.
Well, that's the mootness point.
Yes.
We're not dealing with a mootness issue here.
No. Well, Section 17.1 says leave to appeal may only be given where the judge or judges concerned are of the opinion that A1, the appeal would have reasonable prospect of success, or 2, there's some other compelling reason why the appeal should be heard.
Now there, the judge concerned is Tlhapi J.
Well, it's Tlhapi J in the High Court when the application is made to Tlhapi J. But then one has to go to Section 173 of the Constitution and see there that the Supreme Court of Appeal, notwithstanding what has been decided by the High Court, the Supreme Court of Appeal has the inherent power to protect and regulate its own process. So one looks then at the powers of the Supreme Court of Appeal in Section 19 of the Superior Courts Act.
So do you say that it's quite conceivable that Tlhapi J exercised her statutory powers permissibly by granting leave, and in that sense, there was an appeal serving before the SCA, but that in the inherent exercise of its constitutional jurisdiction, or its inherent jurisdiction, the SCA refused to deal with the appeal. Is that the argument?
That's the first argument. But the second argument is that it is open to the Supreme Court of Appeal in terms of the powers that it has in Section 19 of the Superior Courts Act to reassess the merits of the leave to appeal. And remember that we had firmly placed this before the Supreme Court of Appeal. We argued before Judge Tlhapi that the matter was not appealable because it was not in the interest, Zweni, and not in the interest of justice that the appeal be granted. Justice Tlhapi granted leave to appeal. When the matter went up to the Supreme Court of Appeal, we raised the same point again. And we said this matter is not appealable because it's not in the interest of justice that the matter be appealable. In terms of
sorry if to interrupt, but isn't Section 19 telling us what the SCA can do, what orders it can make in respect of an appeal pending before it? Now, yeah, that's the appeal against the grant of the interim interdict. There was no appeal against the granting of leave to appeal, nor could there be.
No,
sorry.
We raised the point, but our submission is that is the power is also located. First of all, Section 19 or any sections of the Superior Court Act can't take away constitutional powers that are vested in the Supreme Court of Appeal. That's the first point. But if one looks at Section 19 of the Superior Court Act, 19 says the Supreme Court of Appeal, in addition, or any division exercising appeal jurisdiction may, in addition to any power as may be specifically be provided for in any other law, which would include the Constitution, D, confirm, amend, or set aside the decision which is the subject of the appeal, and render any decision which the circumstances may require. So the Supreme Court of Appeal has the power when an appeal is on its roll to render any decision which the circumstances may require. And if the discretion exercised by the High Court is one which can be reassessed because it's the exercise of a discretion in the loose sense, then it is up to the Supreme Court of Appeal to impose its own view of the appealability and replace the decision, make any decision which the circumstances may require. And the circumstances required the SCA to hold that the matter was in fact not appealable.
Can I take you back to something I raised with Mr. Kaitobi, which is Section 16.1. You have referred of the Superior Courts Act. You have referred to the jurisdiction which the SCA has exercised for over a century. Section 16.1 says, subject to Section 15.1 in the Constitution and any other law, an appeal against any decision of a division lies. And then now, at least until recently, when the SCA struck matters from the roll because they were not appealable orders, it was based on an interpretation given to the word decision or order or judgment contained either in the Supreme Court Act or now the Superior Courts Act.
Yes. Because
it said we only have jurisdiction if we are dealing with an appeal against an order or a decision. And
yes.
Do you have any submissions as to what the phrase any decision means in Section 16.1? In other words, I rather understood the applicant's argument now to be that this represents a substantial break from the past, and that decision there mustn't be interpreted in line with the way order or judgment has been interpreted. In other words, generally a decision having the Zweni attributes, but perhaps subject to the interests of justice qualification as well, or relaxation. They seem to now argue that decision has a completely different meaning. It means any ruling or I suppose decision in the common sense is Is that the approach that the respondents also take?
No, Justice Rogers, that's not our approach. Our approach is that the word decision in 16(1)A, B, and C all relates to a judgment or order as understood in the old jurisprudence of the appellate division and then the Supreme Court of Appeal. And it cannot be any decision in the common understanding of a decision, because if one reads further, for example, in 16(1)A, it says any appeal against any decision of a division as a court of first instance lies upon leave having been granted. And one would not expect leave to be granted when you're dealing with a postponement, or when you're dealing with a ruling about whether a witness can be excused, or
yes. Well,
yes.
So the century-long practice was essentially to say a decision granting leave by the High Court cannot convert something into a decision that is not by statute and properly interpreted a decision. That's why it's a jurisdictional matter for the SCA. That was certainly the traditional approach.
Yes.
And it seems to me a potential question, and one of general public importance, may be whether the word decision under Section 16 still has that jurisdictional limitation for the SCA, appellate jurisdiction, albeit subject, because as I understand Howie P's decision in S versus Western Areas, which I think was one of the first SCA judgments which took on board the interests of justice learning from the Constitutional Court. They said, although decision must still generally be interpreted in line with Zwane, it will also qualify as a decision, and that was in the context of a criminal case, where the interests of justice so dictate. So a decision is now either a Zwane decision or a decision lacking some of the Zwane features, but which it is in the interests of justice to be heard as an appeal.
Correct, and that is our submission as well. In fact, that judgment of Howie P was the early case in 2005, which is then referred to with approval by Moseneke J in the score decision.
Yes. So
yes, our submission is that the word decision in the various subsections of 16(1) must have the meaning that was attributed to judgment or order, but then as understood with the gloss that Howie P put on it in the 2005 case. It cannot conceivably be a reference to any decision, no matter how minor or peripheral to the proceedings before the lower court.
Thank you.
Mr. Becker, you have had about 48 minutes.
Yes.
Are you happy to proceed to your, I heard that you are not pursuing strongly the point about direct appeal. Do you leave it to us to look at your written submissions and want to go to your last point?
ACJ, I just want to pick up a few points that our learned friend, Mr. Nilkai Toby, mentioned. I'll pick them up very quickly and then move to the merits. I'm not going to repeat the argument on direct access. As I said, we put it there for a specific purpose. Our learned friend says that the order of Klapi J is final in effect. We've made the submissions why it is not final in effect, and also a Sutherland AJA in our submission in a convincing judgment explains why the decision is not final in effect. And our reference, I would just refer back to our heads of argument, page 20, paragraph 62.1, where we make reference to the Sipler judgment and the Cronshaw judgment. And it's been a long-standing principle of our courts that that just because time has run, as was said in Cronshaw, doesn't mean that the order is then converted into one of being final effect. And that the order, it was also suggested that the order imposed terrible burdens on Mr. Holomisa and the UDM, and that's simply not so. The order specifically says that he must take down the posts. They must take down the posts where they've published the letter, and that is on the UDM website. And it is certainly within their power to take down a post on your own website. And secondly, to delete the tweets, their own tweets, the UDM tweets and Mr. Holomisa's tweets. And again, it's perfectly within their power to delete those tweets. It happens every day. The order then says, and insofar as it is within your power to take down linked tweets, but if it's not within his power, then he's under no obligation to do so. The main thrust of the order was to take down the posts made by the UDM and Mr. Holomisa.
Mr. Berger, at para 17 of the SCA, I would like to understand what it means, where it says it is notable that the effect of the High Court's order prevents merely a repeated publication of the allegations for a time, but not permanently. What does that mean? Especially where we know that the order was issued in July 2018, and the appeal was heard almost 2.5 years later. There's some permanence on that.
Justice Mhlantla, what Justice Sutherland is saying there, that the effect of the court order was to prohibit a repetition of the defamatory statements in the letter until the conclusion of the civil trial. And the fact that it has taken almost 3 years for the matter to come to trial is not something that can convert the judgment of the High Court from an interim order into a final order. The fact that the parties have, to use the words of Justice Sutherland, shuffled their way towards trial doesn't convert the interim order into one of final effect.
Even if the applicant ends up not being able to do anything during that period.
Well, yes, Justice Mhlantla, because there was an avenue open to the applicant. First of all, Justice Tlhapi ruled that the applicant had not placed before her any proof that the applicants would suffer harm, and on the opposite side, the respondents, as we were applicants before her, but my clients certainly put evidence to show that they would suffer and were suffering severe harm. So the balance of convenience was weighed in my client's favor. The matter then wound its way, and it took a while for Justice Tlhapi to give her reasons, and it took longer for Justice Tlhapi to hear the application for leave to appeal. But during all of that time, the matter was, there was a notice of application for leave to appeal. And so sections 18.2 and 18.3 became of application. If the applicants before this court, if the UDM and Mr. Holomisa could demonstrate irreparable harm on their side and a lack of irreparable harm on my client's side, then they could have applied to court for an order suspending the judgment of Tlhapi J. But they never did so. So it didn't, the fact that it took so long to get to trial didn't affect their rights under sections 18.2 and 18.3, and certainly didn't convert the order into one of final effect.
The other point that the SCA raises is that Mr. Holomisa can repeat these allegations in Parliament. That's at para 26 of its judgment. Now, how does one do that when one is faced with a court order that prohibits him to make the allegations?
because Justice Mhlantla, if I could go to Section 58 of the Constitution, and I'll pull it up in a moment. Yes, it's there. It says, Cabinet members, deputy members, and members of the National Assembly have freedom of speech in the Assembly and in its committees, subject to its rules and orders. And B, are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything they have said in, produced, before, or submitted to the Assembly, or revealed as a result. I've paraphrased, but the point is that in terms of Section 58 of the Constitution, a member of the National Assembly is not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything that they've said in the House. So besides the fact that it's always been understood, it was understood before Tlhapi J, it was understood before the Supreme Court of Appeal, that Mr. Holomisa and the UDM could, despite the order of Tlhapi J, repeat the allegations in Parliament. The fact is that there's an absolute constitutional protection against civil or criminal proceedings, arrest, imprisonment, or damages. So if Mr. Holomisa or the other member of the UDM who sit in Parliament had stood up in Parliament and repeated the allegations in the letter, despite the order of Tlhapi J, there would have been no consequences for them because of this protection in Section 58. So the bottom line is that the writ of the High Court does not, it must stop at the doors of Parliament because of Section 58. There can be no civil or criminal liability because Mr. Holomisa or the UDM flouted the terms of the order within the confines of Parliament. So it's quite correct that that throughout the period of this case, Mr. Holomisa and the UDM have been free to repeat the allegations in Parliament, and significantly, they haven't done so.
Well, let me ask you this question, Mr. Becker, arising out of that question by Justice Mhlantla, and this might go to, it might provide an overlap with the issue of the merits. How do your clients satisfy or show that if the interdict wasn't granted, they would suffer irreparable harm in circumstances where it was common cause that Mr. Holomisa could repeat the same allegations in Parliament? How does that, how do they show that?
Well, it is in the merits, but I'm happy to answer that question now.
Yes.
ACJ.
Yes.
If you turn to the founding affidavit at page 29 of volume 1.
Yes.
And you look at from paragraphs 19 all the way through to 25. In particular, in 22, we'd sent a letter of demand. There was no response received to the letter of demand. In 23.2, SAFM reported on our intention to sue the respondents. 23.2.2, in response, the second respondent, that's Mr. Holomisa, he tweeted that he was laughing at my client's attempt to sue him. It was then reported in 23.2.4 on SAFM that Mr. Holomisa said he will not back down and retract the statements in the letter. Then if one goes to 23.3, on the 23.3.1, the second respondent tweeted, this was a tweet he tweeted on the 1st of July. He said, the proximity of Harith and Lebashe directors to PRC is making an interesting read. We are spot on. They seem to be trusted indunas. The sooner President Ramaphosa agrees to investigate his fellow comrades like Jabu Moleketi and other hyenas, the better. So now the pretense of, well, this just needs to be investigated has dropped. And now Mr. Holomisa is saying our allegations are spot on and these are hyenas or rapacious scavengers. Then there was in 23.4.1 an interview on radio 702. And in 23.4.2, the second respondent repeated in this interview the substance of his false allegations, and once again stated that he and the first respondent had no intention of backing down. The reason I'm quoting all of this, and there's a bit more, is that all of these paragraphs from 19 to 25 are admitted in the answering affidavit. 23.5.1, the second respondent considered our demand to be a joke and is once again using his political power and support base to drum up support for his views and allegations. He believes himself entitled to degrade and insult us even further, simply riding roughshod over our rights, also admitted. And then 24, as at the date and time of signature of this affidavit, the letter and its sequelae have not been removed from the UDM website or the Twitter account.
Sorted, I think.
And then in 20,
fine. Yes.
Yeah, just leave it.
Thanks, President.
Sorry, Mr. Mpofu,
Oh,
please mute yourself.
I'm very sorry, ACJ.
Yes, okay, all right. Thank you, Mr. Baker.
And then finally in 26, the allegation is made on the strength of these facts. We conclude, as I submit, we must reasonably do that the respondents will continue their unlawful campaign against us. And you will see that in the answering affidavit, this paragraph is just noted. There's no denial of this paragraph either. So as Klapi J correctly found, there was the applicants before her were justified and had shown grounds for believing that this defamation would continue and that Mr. Holomisa and the UDM would continue to defame them. So that's the one thing, and that's why there was this need to go to court to stop this, because otherwise there would be irreparable harm suffered, loss of business, loss of reputation, particularly for people in the particular field in which they are. The nub of the question to me, ACJ, is, well, why then, why is there such a problem if Mr. Holomisa can stand up in Parliament and repeat these allegations? And the point is because everybody knows that there's an absolute immunity in Parliament. So these allegations have been made in the public domain. Our clients have, as a result, lost business from one client already. Another client has called for a meeting because these allegations are serious. And Mr. Holomisa and the UDM show that they have no intention of backing down and in fact intend to continue their campaign against my clients. If they don't go to court to get an interim interdict, they will continue to lose business, they will continue to be defamed, and their clients will legitimately form the view that they have no defense. They have nothing to say about Mr. Holomisa's allegations against them. So they go to court and they get an interim order of the High Court. That restores the confidence of clients, and that stems the harm that they know they've suffered, and hopefully future harm that they will know, that they won't know that they've ever suffered. The fact that with that order, Mr. Holomisa can go to Parliament and make these allegations again is like duck's water then off the backs of the clients, because they know that a court has stopped Mr. Holomisa, but the writ of the court doesn't extend to Parliament. So he can ramble on in Parliament and people won't take him that seriously. But if we don't have the order, if we sit back and wait for 3 years before we can sue for damages, the harm that will be done, because people will say, you had nothing to say. You had nothing to say to challenge Mr. Holomisa's allegations against you. But what the order of Club PJ shows is that we had lots to say, and a court agreed with us. Okay, so our submission is that there's a difference.
Thank you. I think there was a colleague who wanted to ask something at the time I asked the question. Was it you, Justice Madlanga?
Yes, it was, ACJ. Thank you very much. I want to take you back to the onerousness of the order, Gregor. It may well be that what I'm going to raise does not necessarily tie in with the applicant's argument. I must confess I've forgotten what the true nature of the argument is in this regard. This is what I want to say. The practice of politics is, amongst others, about taking up issues, speaking on them, raising political controversies, speaking on them. Therefore, an interdict of this nature has the effect of curtailing, if not stopping or bringing to a complete end what the practice of politics is about. Granted, this may be with regard to just one issue, but if it's an important issue for the political party, that in itself is quite far-reaching. And in that sense, I would say the order is quite onerous, apart or despite the issues that you raise specifically, which relate to, for example, just removing a tweet from a Twitter account, which is what is physically possible. And because, according to you, that is physically possible, then the order is not onerous in that sense. But if you look at what the practice of politics is about and the effect of an interdict of this nature on that, in my view, the order would be quite onerous. What do you say to that?
Justice Madlanga, you raise a very important point, because what this suggests, and it's a point that is alluded to in our learned friends' heads of argument as well, that politicians are in a class of their own, and that the laws of defamation of our country should not apply.
I'm not even going that far. I'm not even saying they should be on some sort of pedestal. There may be other professions as well, or other categories of people or persons who, like politicians, may also make a similar claim. But I'm just focusing on politicians because we're concerned with politicians here. But I'm by no means putting them on a pedestal. And I would like you to address my point in that context and not necessarily putting politicians on a pedestal.
But Justice Madlanga, this case, first of all, is not about political speech, because the letter, my clients are not political opponents of the UDM or Mr. Holomisa. My clients are not politicians. Yes, Mr. Moleketi was once a minister of finance, but by the time this letter was sent out, he was long since the deputy minister of finance. If politicians, the argument is made that politicians are about accountability, and when politicians speak in Parliament or outside of Parliament, they are seeking to hold their political opponents, and particularly the executive, accountable. So for that reason, they shouldn't be stifled by the regular laws of defamation. Firstly, if one is going to embark upon that exercise to say that politicians and perhaps others are entitled to special protection and greater protection in the law of defamation, then there's a whole process that has to be undertaken. As this court set out in the mighty, I forget the full name of the case. There's a judgment of this court. There's another one, MEC for Health versus DZ. And it's also repeated again in EFF versus Manuel in the Supreme Court of Appeal. The process that must be undertaken if a party wants to develop the common law, and in this case, the common law of defamation, or the common law relating to interim interdicts. And certainly there's been no evidence put before the High Court or the Supreme Court of Appeal or this court, which would justify politicians, which would justify a development of the common law insofar as politicians are concerned. And then thirdly, Justice Madlanga, there is no reason why politicians ought not to be held to the same level of scrutiny as, for example, the media, because the media is also about accountability. And this court has held in Kumalo versus, ironically, Kumalo versus Holomisa, that the civil law of defamation has struck a proper balance with the since the Bokhoshi judgment. So the media are constrained in what the media publishes, and certainly the media holds all politicians to account, and that's one of the functions of a free media. But there's no suggestion that the media are elevated in an elevated position over other citizens insofar as whether they can get an interdict against publication, or someone can get an interdict against publication against the media. The media still has to show that they acted reasonably in the circumstances. And there are good reasons why the Bokhoshi judgment doesn't apply to people such as Mr. Holomisa or myself. But politicians have such power, particularly the power that is granted by Section 58 of the Constitution. A politician can stand up in Parliament and defame ordinary citizens without the fear of being sued. Those ordinary citizens don't even have to be politicians. Those ordinary citizens don't even have to be members of Parliament. So a member of Parliament can stand up in Parliament and defame me, and I will have no recourse against that member of Parliament. To extend that privilege beyond the confines of Parliament would be to elevate politicians beyond all citizens. So the right to freedom of expression of politicians would be enhanced, and the right to dignity of ordinary citizens who are not politicians would be diminished. I can't stand up in the town square and defame a member of Parliament without due cause. But a member of Parliament can stand up in Parliament as the Constitution stands and defame me, and now they want to have the privilege of defaming me outside Parliament as well. Justice Madlanga, it would simply be giving politicians greater rights than ordinary citizens, and there's no basis for that upon which this court can come to such a conclusion. The two cases that I was referring to was Mighty Solutions versus Engen Petroleum, 2016 1SA 621 at paragraph 38, and MEC for Health versus DZ on behalf of NZ, 2018 1SA 335.
Thank you, Mr. Berger.
Mr. Berger.
I'm sorry, I muted myself without seeing. Justice Madlanga, you are done.
Mr. Berger.
Yes, okay.
Yes, I am, Acting Chief Justice. Thank you.
Yes,
Thank
Justice
you.
Madlanga.
Yes,
Okay.
I have a question for you. It's something I don't quite follow. You say Mr. Holomisa will be entitled to repeat the statement in Parliament.
Yes.
So will that not be against the rule of law to have an interdict against him, and on the other hand, repeating the very same thing from which the court has been prohibiting him to do?
No, Justice Madondo, and the reason I say not is because Section 58 of the Constitution gives members of Parliament an absolute right to say anything within Parliament without fear of being subject to civil or criminal proceedings. So, for example, there could be no criminal case brought or civil case brought for contempt of court against Mr. Holomisa if he uttered the same words within Parliament. Section 58 would prevent that. And so my submission is that the writ of the High Court must stop at the doors of Parliament insofar as interdicts, defamatory interdicts are concerned.
So does this section apply even to people who are not members of Parliament?
Justice Madondo, Section 58(1) of the Constitution says it applies to cabinet members, whether or not they are members of Parliament, deputy ministers, and members of the National Assembly. So as far as the Constitution is concerned, it applies to these three categories of persons. And it says cabinet members, deputy members, and members of the National Assembly are not liable to civil or criminal proceedings, arrest, imprisonment, or damages for anything that they have said in, produced before, or submitted to the Assembly or any of its committees. It's an absolute privilege against civil or criminal liability.
Okay. The other question, will you say in this matter, the intention to defame was established?
Justice Madondo, in the law of defamation, once the plaintiff proves the publication of defamatory material concerning the plaintiff, then the two presumptions of law arise. One is that the defamatory statement was made animo injuriandi, with intention to defame unlawfully. And the other is that there's a presumption of unlawfulness. So, and of course, all of that is prima facie for the purposes of an interim interdict. So prima facie, there's a presumption that there was an intention to defame, and then it is for the respondent in the High Court to set up a sustainable foundation, to use the words of all the cases, including Herbal Zone, to set up a sustainable foundation for a defense that he lacked the intention, that he lacked animus injuriandi. And on the papers before the High Court, there's nothing to set up a sustainable foundation. And I'll deal with animus injuriandi now, whilst I'm speaking about it, because the respondents, applicants before this court, there's no evidence that, and in fact, my client said the contrary. All they say is they got information from a whistleblower, and they scratched themselves, and they came up with the allegations in the letter, which I will deal with in more detail in a moment. There's no consulting of the respondents. We said they didn't consult us. They don't deny that. There's no consulting of the records of Parliament, to which Mr. Holomisa and the UDM had access in relation to the affairs of the PIC. They don't deny that. There's no consulting of company documents, which are publicly available. They don't deny that either. So there was nothing done other than getting this information, they say, from the whistleblower, and whatever their scratch work was, which nobody knows because it isn't articulated in the answering affidavit. There's nothing there to show that any steps were taken to verify the veracity of the allegations in the letter. And so it would be very difficult for the respondents on the basis of the answering affidavit to argue a lack of animus in Uriandi. And they never argued that before Tlapij.
So, Mr. Becker, but now there's the fact which seems to be common cause that they requested the president to investigate the matter. My understanding, you correct me if I'm wrong, such a request was indicative of the fact that those allegations are still to be verified. If they intended to defame the respondents, would they ask for such an investigation?
Well, Justice Madondo, it could be both. It's not an either or situation. On the one hand, the applicants say that it's not for them to prove the truth of the allegations in the letter. That's why they asked the president to establish a commission of inquiry, or to extend the terms of reference of the State Capture Commission. So, and they say, well, we don't know whether it's true or not. And that's why we're asking for an investigation. But if you don't know whether it's true or not, then you can't announce to the world that my clients are guilty of corruption, fraud, fronting, and a host of and large-scale theft and looting of the PIC. You can't announce that to the world without having an intention to defame them. And once you've announced it to the world, it's for them. It's for them to put evidence before the court to show that they didn't have such an intention. And that evidence is sorely lacking. Perhaps it's unless there are any questions on jurisdiction or whether the SCA applied the correct order, perhaps it would be appropriate for me to turn to the merits of the case.
I have one question. Oh, sorry. I have one question on the applicability of the matter of the order in question, because my problem is this order. If I look at it, it's somehow final in effect, in the sense that it was in no way subject to any reconsideration by the court which issued this order.
Justice Madondo, it's not final in effect, and I don't want to repeat the arguments in our heads of argument, because they're all there, and I'm not going to repeat the arguments of not the argument, the points made by Justice Sutherland in his judgment, because he also explains why the order is not final in effect, and we support all of those grounds as well. But in a nutshell, the order is open to reconsideration, and that's because the High Court was asked to grant an interim interdict. So the High Court had to be satisfied that my clients had made out a prima facie case, that they had a clear right or a prima facie right, though open to some doubt. They had a right not to be defamed unlawfully. So the finding of Justice Tlapij is that they established that prima facie right. They also established that they would suffer irreparable harm. They established that the balance of convenience was in their favor. They established that there was no suitable alternative remedy because their reputations would have been destroyed by the time the matter came to trial, and the losses to the businesses would never be able to be quantified. They established all of that, but none of that is binding on the trial court that will sit next Monday. That trial court will have to establish whether the statements are indeed defamatory, which is something that Justice Tlapij did not have to establish. And the trial court will have to establish whether not only is there a sustainable defense, but whether the applicants before this court or the respondents in the High Court have discharged the onus on a balance of probabilities that either they had no intention to defame or B, that they did not act unlawfully. So I guess the short answer is that none of the findings of CLA PJ bind the trial court. And that for other and for other reasons is why the order is not of final effect, because it disposes of nothing.
Mr. Bernhardt, just on one aspect, I should have raised this just after Justice Mhlandla. It's in relation to irreparable harm. And yes. As I understood your answer to the ACJ, is that it seems the purpose of the order is intended to show that you did not leave these words or these statements lying there for purpose of defamation claim. Because if these remarks are made in Parliament, where there's immunity and they are live streamed and social media picks them up from there, which might even cause more harm than if the tweets that the applicants have made in their social media account. There will be more harm if they are there. So the whole purpose then of this interdict, which appear not to have been considered in detail by the majority has taken into account, has noted, in fact, that the message has been carried to the public already, which means the horse has bolted. And that did not appear to play a role in considering as to where these orders are granted in exceptional circumstances. Is this not a case that they should have considered?
Justice Tlaletsi, there are a number of points there, and I hope I do justice to all of them. The first is that it's not correct to say that interim interdicts of this nature are only granted in exceptional circumstances. The cases starting with Hicks and following certainly do not say that interim interdicts of this nature are only granted in exceptional circumstances. Interdicts of this nature are granted if the applicant for the interim relief is able to satisfy the court that he or she has satisfied the 4 elements for an interim interdict, and then there's an overall discretion in the High Court as to whether or not the interdict is granted. But there's nothing to say that such interdicts are exceptional and only granted in exceptional circumstances. I'm talking about interdicts of this nature. The second point is that Justice Tlaletsi, you said that by repeating the defamatory allegations in Parliament, that would do more harm than a tweet. Well, Justice Tlaletsi, with respect, I'm not sure that is so. There's a lot more activity, I would venture to suggest, on Twitter than there is on members of the public tuning in to debates of the National Assembly. But that's besides the point, because everybody knows that members of Parliament have the right to say whatever they want in Parliament. In fact, there's a common refrain when it is said by one member of Parliament against another member of Parliament, then the other member of Parliament stands up and says, come and repeat those allegations outside the House. And I'm sure we've all seen that on debates in Parliament. And that's because if you repeat those allegations outside the House, then you no longer have that absolute immunity. And the third point I would make is that if this court were to find that or were to hold on the evidence currently on record that politicians are entitled to say whatever they wish. Because in Parliament, you can say whatever you wish. It doesn't have to be germane to the issue. It can be about anybody. It can be about anybody's granny. It can be literally about anything that comes to mind. They can say that without fear of civil or criminal liability. To say that a parliamentarian is entitled to say that outside of Parliament would mean that the laws of defamation don't apply to politicians, or certainly don't apply to members of Parliament. And that would be an amazing development in our common law, and one which we would submit is not justified, certainly not as on the record before this court, and not as a matter of public policy either, for parliamentarians to be absolutely immune from the laws of defamation. Our learned friends may say in reply, well, no, we've exaggerated. It doesn't mean that will apply to every statement made by a parliamentarian outside Parliament. But then where do you draw the line? At the moment, a statement made in Parliament is absolutely protected, and so there's no need to draw a line. Where do you draw the line when you're outside Parliament? And again, there's been no argument on that base on that point, and no evidence produced on that point. I hope Justice Alexi have answered the argument.
Yes, but then on your response that the order was obtained so that in future, when there are defamation proceedings, you should be in a position to say you did challenge these statements. Otherwise, they will be assumed to be true.
No. That's not the point I'm making. The point I'm making is that the applicants before Judge Tlhapi provided evidence to show that they were suffering harm. There's in the founding affidavit, there is evidence before the court to show that they have already suffered harm as a result of the publication of the letter. And there's a fear that they will continue to suffer harm because and they make this point as well, which is not challenged. Their honesty and the trust that people place in them, their integrity, is at stake, and so they had to go to court to challenge that letter and to get an interim order to say that those statements are defamatory prima facie. There's no sustainable defense. And so therefore the statements are interdicted. It's not just to come to the trial court and to be able to say, well, we challenged those statements. It's to deal with a situation from 2018 until the matter gets to trial, where if an interim interdict was not obtained, my clients' reputations would have been in tatters by this stage, and their businesses would have lost would have suffered such losses that they would never be able to quantify. And that case is made out in the founding papers. And there's no rebuttal of that case in the answering affidavit.
Thank you, ACJ.
Thank you. Mr. Brecker, you have had about 1.5 hours. So I think, I know we have asked you questions, but I think you might wish to try and finalize.
Can I then quickly go to the merits of the case? I'm not going to go through the letter in detail. We've gone through the letter in detail in our heads of argument. The letter is clearly defamatory of my clients. The allegations, if I can just go to the letter. The allegations in paragraph 1 that The information about my clients could make the Gupta family's alleged capture of state look like chump change. In paragraph 2, as forewarned in those letters, the iceberg of corruption is rising day by day. There's information of individuals and companies who might be knee-deep in the more than a decade's worth of pillaging the PRC. Look at paragraph 3 of the letter. The crux of the matter is that there is an allegation that Dr. Dan Machila, the current PRC CEO, is, pardon the colloquialism, in bed with my clients. It is alleged that Dr. Machila uses his approval limit of up to 2 billion to avoid having to get the board to approve deals. It is alleged the PRC has thusly funded these gentlemen in certain deals in 1 year. And then one goes to paragraph 5. The above reads like a spy novel with incomprehensible twists and turns, only clues as to the real nature. From above information, one can see there's a complicated system at work to apparently hide the fact, that the PRC is being fleeced at an astonishing pace. And then 7, Mr. President, instead of being a giant machinery that creates wealth opportunities for South Africans, it is clear, and there's no hiding behind alleged or any of those similar words. It is clear that individuals such as names my clients, including Mr. Machila, are at least double or triple dipping, in other words, illicitly doing so in the PRC's funds. In fact, one shudders to consider how many conduits they have at their disposal to sap PRC funds. If I can make one submission, which it just gets consistently ignored by our learned friends. The allegations, if one looks at the answering affidavit, it was also ignored by the minority judgments in the SCA. The allegations in the letter are very specific. The allegations about being in bed with Dr. Machila, about avoiding the 2 billion rand limit and getting money, looting the PRC through that. Those are the allegations which we highlighted. We highlighted all of those allegations before CLAPJ. And those are the allegations that are defamatory of my clients. And to suggest that there's any evidence in the answering affidavit which even comes close to attempting to prove the truth of those allegations is to misread the answering affidavit. The answering affidavit goes on about conflicts of interest. It goes on about Section 96 of the Constitution, the PFMA, Section 58 of the Constitution, Section 16, Section 19. There's none of that in the letter that Mr. Holomisa and the UDM sent to the president and published to the world. There's nothing about conflict of interest in the letter. There's nothing about Section 96 of the Constitution or the javelin or anything. The crux, and I don't think this can be gainsaid. The crux of the letter to the president is that there are allegations of corruption, looting, fronting, large-scale theft of PRC funds by my clients in concert with Mr. Machila from the PRC. There's nothing of that. There's nothing in the answering affidavit of anything about Mr. Machila, except my client said in the founding affidavit, it's not true that Mr. Machila has approval limit of up to 2 billion rand. And Mr. Holomisa's response is, how would you know that?
Mr. Becker, I propose to give you 5 minutes more. Is that fine?
It will be fine.
Yeah.
ACJ.
Okay.
So the point is, and we would urge this court to carefully read the answering affidavit to see what facts does Mr. Holomisa allege. The fact that he says it's common cause now that Mr. Moleketi was a deputy minister and he's the chair of this company or the chair of that company. Those are not the defamatory allegations that caused such damage in the letter. And then just to give the references in the answering affidavit, where Mr. Holomisa says this is not about the truth of the allegations. We found at paragraph 16, He says this will be investigated. Paragraph 51, the reason why such words have been chosen, 16 was at 134, 51 is at 147. The reason why such words have been chosen is precisely to demonstrate that the allegations are not confirmed. 148, paragraph 56, it must be recalled that this case is not about the truthfulness of the allegations. Our learned friend's argument that there's a word slipping, that there was a word left out here with respect doesn't help the situation. It's a constant theme through the affidavit, and it's never been suggested that there was a mistake in the answering affidavit. It's a constant theme throughout the affidavit that it's not for me, Mr. Holomisa, or the UDM to prove the truth of these allegations. So our submission is that there's clearly no sustainable foundation for a defense of truth or a fair comment or protected comment. There's no evidence, as I've said before, about a defense of a lack of animus injuriandi. And the other points about section 19, 16, 19, 58, and 96. We've dealt with those allegations in our heads of argument. There's really nothing in those arguments. For example, section 16 of the Constitution, that's already balanced in our law of defamation with the right to reputation. 19, the right to political activity. The UDM and Mr. Holomisa are free to pursue their section 19 political rights, but they can't do so at the expense of savaging my clients' reputations. A line must be drawn even in political activity. You can't go about savaging the reputations of individuals who are not your political opponents. So the section 19 rights there is no section 19 argument in this case. 58 is clear. It's confined within Parliament. I've explained our submissions why. And 96, there's nothing in the letter about 96. There's nothing in the letter about conflicts of interest. There's nothing in the letter that worries or that raises a section 96 argument. The gist of the letter, the whole crux of the letter, if read by any ordinary person of ordinary intelligence, which is always the test, the gist of that letter is a large-scale, unjustified attack on my clients that they were involved or could be involved in large-scale looting, fronting for white business, sapping illicit funds, bypassing board resolutions, and thereby stealing money from the PRC. And there's no justification for that. And to suggest that Mr. Holomisa should be able to do that in the exercise of his political rights is once again, as I've submitted, is to elevate the status of a member of Parliament so far above ordinary citizens that members of Parliament are no longer subject to our laws of defamation.
Then that's where your 10 minutes ends, Mr. Berger. Is that fine?
That's fine with me, ACJ. Thank you very much. And
yes.
Thanks to the justices as well.
Yes, I apologize to colleagues. We were supposed to take a lunch break at 1, and I thought Mr. Berger was close to finishing and we would try and finish. But maybe we should try and just have the reply and finish before we take the lunch break, colleagues. Yes, okay, all right. Mr. Mpofu and Mr. Ngogaitobi, may I assume that only one of you will respond?
Yes, that will indeed the case.
Okay.
We would have preferred to both speak, but in the interest of time.
Yeah.
Yes.
Yes.
Thank you.
Okay. All right. Okay. All right.
Thank you, ACJ and justices. I don't know if you can see me. I cannot see myself on the screen.
I can't see you. I see where your picture is supposed to be, but I can't see you.
Yes. Can you see me now?
No.
Because I was on gallery and I'm now on speaker.
Don't you have, sorry, ACJ?
Yes.
Don't you have a little flap that's covering your camera that you should maybe slide to the side?
No, no, I can't. I can see everyone when I go to gallery except myself.
Oh. Are you happy to address us without us seeing you?
I am.
Okay, all right. Let's do that.
Thank you.
All right. I'll give you 15 minutes.
Thank you, ACJ. Right, ACJ, let me start very quickly on the issue of appealability. I don't want to belabor the point. I just want to make too few submissions. One is to piggyback on something that was raised by Justice Rogers. And that allows me to kill two birds with one stone, so to speak, and talk about appealability and jurisdiction in the same breath. And it is this: if we accept for a minute that one of the issues that arise in this case is the interpretation of Section 16 and 17 of the Supreme Court Act, and more particularly the interpretation of the word decision in Section 16, then in my respectful submission, that alone, that interpretational exercise would in itself grant this court jurisdiction, because it's an interpretation of a statute that has something to do with Section 34. And by that, I'm referring to the very initial question that you raised, ACJ, regarding the application of those sections vis-a-vis the right to appeal, which is a Section 34 right. So that alone would grant us direct jurisdiction in the sense that the matter raises a constitutional issue. But even if we are wrong in that, then the scope or ambit of the appellate jurisdiction of the SCA would in any event be a matter of public importance, of general public importance, which requires the attention of this court. So on either legs, with flying colors, we would pass the jurisdiction test. There's no doubt about that. But now let's then come back to the issue of decision. I said earlier that it is clear that there are two distinct decisions that were made by KPJ, one being on appealability, and then on the application to leave, rather on leave to appeal. So I won't repeat those submissions. Just want to bolster those decisions, or rather those submissions, by making reference to what Justice Rogers, the question he put to my learned friend as to how we conceptualize the word decision. It is indeed so that we conceptualize the word decision in its wide or ordinary dictionary sense, if you like. And we draw inspiration in the fact that the Zweni test, the old Zweni test, let me put it that way, amounted to something like this: that if you failed the Zweni test, that was the end of you, basically. The classical Zweni test, the three-legged Zweni test. But the new test is that makes it possible for you to fail, quote unquote, the three-legged Zweni test and still if the interests of justice nevertheless are in your favor, the matter would still be appealable. In other words, pre-outer, if you failed the Zweni test, that would be the end of the matter. But now, post-outer, you can fail the Zweni test, but the interest of justice can still let you into the game, so to speak. And that's really the difference, because the majority decided the matter as if the new regime is not in place, as if the Zweni test was the only test. But what is worse is that even, and I hear Justice Madlanga saying that the Zweni test was properly articulated and so on. Well, we would differ slightly, because not only was the test, well, it might have been well articulated, but it was at the very least misapplied. And I say that because if you look at paragraph 11 of the judgment, which is on volume 6, I'm sorry. Yes. The Justice Sunderland says this: applying these norms to the facts relevant to the order in this matter, it may be asked, how might the interests of justice be thwarted if the interim order stands until trial and potentially is then held to have been inappropriate because either there was no defamation after all, or that the appellant's conduct is held to be justifiable? In our respectful submission, that is a misapplication of the test, because it almost introduces through the back door a reverse onus of how might the interests of justice be thwarted if the interim order stands. But that's not the test. The test is why should the order be granted at all, not why it must stand. In other words, there's no onus on us to show why it must stand. The onus would be on the other side to show that it should have been granted apart, irrespective of what we know about such orders being granted only in the clearest circumstances. And that mistake, with the greatest respect, then permeates through to paragraph, I think, 23. Paragraph 23 is really the weakest link of this judgment, because unlike what my learned friend says about section 19, actually this paragraph bolsters our arguments on both section 58 and section 19, because the learned judge said the appellants are in addition not denied an opportunity of repeating the allegations in Parliament because of section 51A of the Constitution, such as a right to do so with impunity. I'll come back to that. Then says the counter argument offered in this regard is that section 19 confers a right to engage in advocacy outside of Parliament, no less than within it. In other words, the wide interpretation of section 58. And then the learned judges say, ostensibly, this is indeed the scope of the section. So let's just pause there. So on the version of the majority, section 58 read with section 19 grants absolute immunity with impunity, as they put it. And therefore that alone would be a defense. And that's why I was saying to Justice Theron earlier, even if, let's say, the truth and public benefit defense was not sustainable, this defense, the section 19 read with section 58, is on the version of the majority itself sustainable. Now, the implications of that go to the questions raised by Justice Madondo and I can't remember, I think Justice Kaleti as well. Namely, what then is the purpose of this interim order? Accepting that it's a type of interim order that should only be granted in exceptional circumstances, or in the clearest of cases, it doesn't matter, but it's rarely given. Then why give it here when, as we know, it is either on the narrow interpretation, these allegations can be repeated every single day in Parliament, every single day for the past 3 years, or on the wider interpretation, which we favor, they can be repeated even outside of Parliament. So for the purposes of this point, it doesn't really matter whether one favors the narrow interpretation, which says you can only do it in Parliament, or the wider one. Either way, it can be repeated and it can be written on every single day in a newspaper. Therefore, that bolsters the finding by Justice Makgoka that this is a meaningless thunderbolt of an order, a mere brutal fulfillment. So whichever way you look at it, there is no justification for a gagging order, as we classify it, or an anticipatory publication order, if one wants to find neutral terms to describe it. Now, this then takes us to the issue that was raised, I think, by Justice Madlanga about...
I'm sorry, Mr. Mpofu, I had muted myself. Just so that you can pace yourself appropriately, you have 5 minutes left.
Okay, all right, thank you. All right, well, I'll try and pace myself.
I'll give you another 5, make it 10, but then it should be 10.
Then that's maximum. All right, then I'm going to time myself. Okay, it's 13:41 now. I'll try and stop at 13:50. Thank you, ACJ. Okay, before I forget, before I come back to Justice Madlanga's point, I just want to say, just to allay Justice Theron's issues about the common cause facts, that if you go to the answering affidavit, you will find chapter and verse of the elucidation of the facts of what we call the common cause facts, which combined make it very clear that this is a case, at the very least, of a smoking gun in terms of corruption. And it is not correct, with the greatest respect, that what our learned friend says, that the letter does not allude to Section 96. For the letter to allude to Section 96, it doesn't have to contain the word Section 96. If it says the man was a former cabinet minister, or rather deputy minister, and he now is benefiting from a position that is related directly to that, then everybody will know that in the context of the South African issues around corruption, that is what I call a smoking gun. So we don't have to articulate the words of the section in the Constitution. This is a letter that was written by a lay person, not by a lawyer. And so if it alleges that you were a deputy minister and you benefited, then obviously the lawyers will summarize that into a Section 96 complaint, so to speak. But and so the common cause facts are sufficient to sustain truth and public benefit in that context. Then I come to Justice Madlanga's point. Well, again, Justice Madlanga was reticent to say that politicians are put on what he called a pedestal. But I want to assure Justice Madlanga that it's not the court or the appellant who put politicians on a pedestal. It's actually the Constitution. Because the Constitution says that if I say something defamatory about Mr. Ngcukaitobi, he can sue me tomorrow. But if a politician and a member of parliament says the exact same thing in parliament, he cannot be sued. So there is no doubt that the Constitution seeks to make that differentiation. It's not one that is being smuggled in by anybody. And we all know the policy reasons why that might be so. But the fact of the matter is that the member of parliament is differentiated from a person like me by the Constitution.
Mr. Mpofu, I think on that one, we are on the same wavelength.
Thank you.
But I was making that point outside of the context of Section 58.
Okay, all right. No, thank you, Justice.
Completely, Mr. Mpofu.
Thank you. Thank you, Justice Makanga. And without belaboring the point, Section 19 even adds to the special, quote unquote, special treatment, because Section 19 also gives rights of campaigning and propagating the views of your political party and so on. But I'm happy if Justice Makanga is happy on that point. Then the other point is about the final in effect, a point raised by Justice Kaleti. Yes, unfortunately, the majority also goes on about this issue about 27 months and the delays and so on. With the greatest respect, that's just a red herring. And I think Justice Mhlahla also raised that matter. That is a red herring. The fact that in this particular case, it so happens that there was lethargy or shuffling or whatever it's called is completely irrelevant. Let us assume that this was the most efficiently run trial. And then there was the interim order, and the following month, the trial ran, and the following month, the appeal ran, and it was all finished within 3 months. It doesn't matter whether it's 27 months or 3 months. The effect of the order is final in the sense that the harm and the onerous effect of that order would still endure for that 3 months, in the sense that the appellant would be gagged to that period. So it's not the length of the period. It's the mere fact that this is such an onerous burden or gagging order that even if it was 3 months, or it so happens that it's long in this instance, but it could have been done with the speed of light. It would still be, even for a week, nobody should be stopped from making these kinds of speech. Yes, then there's, sorry to jump back to the appealability point. Even if one were to invoke Section 173, it would still come short in the sense that Section 173 does not give you inherent jurisdiction basically to do anything you like. It gives you such inherent jurisdiction to regulate those matters which are not otherwise covered by the rules. Now here we're talking about matters which, the issue of decision or no decision, which is not only covered by the rules, but covered by the act, by an act of parliament. So in my respectful submission, the cautionary statement, which is always associated with Section 173, that it must be applied with great caution and circumspection, applies here. And therefore the SCA's jurisdiction, or rather ambit, to undo the order of Justice Kapi still stands. But the biggest point for us is that Section 173 or no Section 173, and even if one accepted that there is a residual jurisdiction of the SCA to regulate its own matters, that must still be done within the law. In other words, the interference with the decision of KPJ on the question of appealability, which is a discretionary matter, and the granting of jurisdiction, must still be only upset if she did not exercise that discretion properly or judiciously. And here there is no, and that's a point made twice by the minority judgments and not addressed by the majority judgment at all. And therefore, we all know that the mere fact that Klapi may have been wrong, let's assume she was wrong in the exercise of that jurisdiction, does not entitle the SCA to reverse that decision willy-nilly. So that point stands, whatever the answer is on these new interesting issues that we have raised in this court about interpretation of section 16 and 17 and so on, just on the plain old methodology of reversals to be done by the SCA.
That brings you to your 10 minutes.
Yes. Oh, okay, well, let me just end it like this by saying that the question raised by Justice Majid, therefore, on this question of the discretion, the reversal of a discretionary matter, was simply not answered at all, because that's simply because there is no answer, at least none that appears from the judgment, as to how it is that the SCA found a way to reverse a discretionary judgment without having criticized the manner in which it was exercised. So on all those submissions, both on the questions of jurisdiction and appealability, which are the in limine points, we respectfully submit that those issues should be decided in our favor. And then on the merits of the appeal, then there is a plethora of defenses or possible defenses, including the one postulated by Justice Madondo on animus injuriandi. But we don't need to even go there. Simply on the what I called earlier the common law defenses and or the constitutional defenses, that those would be sufficient for the judgment of Capi J itself to be reversed as a court, please.
Thank you very much, Mr. Mpofu. Thank you very much. We have come to the end of the hearing. I thank counsel on both sides. We'll reserve judgment and it will be given as soon as possible. Judgment is reserved and the court adjourns.
As the court pleases.
As the court pleases.
Today's proceedings have concluded. The host will now terminate